how long do you what do you intend? How long do you intend on making your presentation?
Depending on the witnesses and how long they take to respond to questions, I shouldn't imagine no longer than 35, 40 minutes.
Okay.
And we're streaming live now.
Yeah. Okay. Perfect.
Okay.
That's what I want to know. Thank you.
Okay. You're welcome.
Good morning, everyone, and thank you for attending today's Augusta Richmond County Personnel Board hearing. I would, without objection, I'm going to go ahead and call this meeting to order. Notice we do have a quorum present. Can everyone hear me? Is council?
I can.
Okay. Is Mr. McDaniel here, and can he hear me? And is he represented by council?
Yes, I am.
Okay. Is your council present?
Yes.
And Mr. McDaniel, if you can turn on your camera, please, sir. Thank you.
Yes, ma'am.
Yes, sir. Yeah, thank you very much.
You're welcome.
And I see his attorney is connecting.
Okay, yeah, I see that now too. All right, once your attorney connects. Mr. Ratley, can you hear us?
I can.
Okay, thank you, sir. I appreciate you being here. I've already called the meeting to order, and I'm just gonna basically give you the basic procedures. We do have a quorum present. I will give you the procedure and how we'll proceed today. So we are an administrative. This is an administrative hearing. The rules of evidence do not apply. And so what we will do is we are here to strictly hear the testimony from the city, their witnesses, and you're the appellant and his witnesses. Our job is to determine whether or not to uphold the city's recommendation, in this case for termination, or to overturn it. There's no other remedy that we have. What we will do is we will first hear from the city. It's their case to prove. We will then allow you to rebut the city's case and present your witnesses and your facts as you deem it necessary. Once we'll do that, we'll have a brief closing, and the board members may have a few questions to ask. Once those questions of the parties involved, once that's completed or satisfied, the committee will then retire to executive session and vote on it and make a decision. We will then come out of the session, and we will let you know what the decision is. From that point, if you disagree with our decision, if either party disagrees with our decision, they have the right to appeal to Superior Court. Does everybody understand?
I do have one issue, Mr. Chairman.
Yes, sir.
You stated that the rules of evidence do not apply to this hearing.
Correct.
According to the Employee Procedure Manual, specifically subsection C, the hearing process, it does say the rules of evidence as applied to the trial of civil non-jury cases in the Superior Courts of Georgia shall be followed.
Oh, I apologize. I misread that. So they will be.
Understood.
Okay. I misspoke.
That may just, in fact, I believe it's in the board's policy. The board has separate procedures. Are you reading the board's procedures?
That's
Correct.
from the board's bylaws on the procedures
Yes.
for this.
And which section was that again?
Section 300.0017, Personnel Board Bylaws,
Okay,
subsection C, hearing process.
okay,
He's correct.
yeah,
Yeah. Um,
You can do whatever you need to do. You can do whatever you need to do. Yeah. You're not stopping me.
anything further?
That's all for me, Your Honor.
Okay. All right. With that, all right, with that being said, I'm gonna go ahead and have so counsel, the city attorney will then swear in everybody's witnesses. What we will do is we will sequester the witnesses outside of the Zoom or however we do that. So they'll be called as needed. But we could go ahead and swear all the witnesses. I believe, I don't know, do we have a procedure where we can swear everybody in now?
yes, they're all going to be admitted and we're all going to, I'm going to swear them all in at the same time.
Okay, all right, that sounds fine. So Ms. Hammond, you go ahead and do that, take care of that, then we will get started.
Will do. And do you have any witnesses, Mr. Radley?
No, ma'am. With the possible exception of Mr. McDaniel.
Okay. I do believe the administrator may be joining us a little late. He may be tied up in meetings. So when he does get on, with your permission, Chairman Barbie, I can just
You can swear him if you're going to use him as a witness and you're ready and you're within the time frame of presenting your case.
yeah.
You can swear him in at that time. I don't have a problem with that.
Okay. All right. Mr. McDowell, I cannot see you, sir. So if you can, thank you. If you and Ms. Poole can raise your right hand, I'll go ahead and issue you the oath. Do you swear and or affirm that the information you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And you all will be placed in a waiting room until such time you're called as a witness. Thank you. Everyone can just mute their mics because we're getting feedback. Okay. Thank you.
All right. So what we'll do is I'll allow for a brief opening from both parties. Ms. Hammond, you can go ahead and begin.
Okay. All right. Thank you. Good morning. Again, my name is Zena McClain, and I'll be representing Augusta, Georgia this morning. Marcus McDaniel was hired by Augusta, Georgia on or about July 31st, 2017. Prior to being terminated, he worked in the Department of Parks and Recreation under the direction of Maurice McDowell. His direct supervisor was Stanley Graham. Today, you are hearing his appeal of his termination from the Department of Parks and Recreation on or about August 3rd for violating Augusta's policies and procedures, including the policy against unlawful discrimination and harassment. Consistent with the bylaws of this board, the evidence I expect to present will consist of the charged violations, the action taken by the department director, and the decision of Augusta's administrator on McDaniel's administrative appeal. As such, I expect the evidence will show that Mr. McDaniel filed a sexual harassment complaint with the EEO division of Augusta's Compliance Department. And after the EEO division conducted an investigation into his allegations, it was determined that McDaniel displayed behavior or conduct that was unethical, harassing, disrespectful, dishonest, and retaliatory. The evidence will show that McDaniel's behavior violated Augusta's personnel policies and procedures. Further, the evidence will show that McDaniel appealed his termination to the administrator of Augusta, Georgia on Wednesday, September 1st, 2021. The administrator met with McDaniel and the department director on Wednesday, September 1st, 2021. The evidence will show that the administrator thereafter issued a decision on or about September 3rd, 2021, upholding the decision to terminate Mr. McDaniel. After hearing all of this evidence, I'll have the opportunity to speak to you again in closing. And at that time, I will be asking that the decision to terminate him be upheld. Thank you. That concludes my opening. I do do you want me to go into my witnesses?
Thank you. I'm sorry, Mr. Ratley, go ahead.
Yes, thank you. And my name is Kenneth Ratley. I am representing Mr. Marcus McDaniel. I have one simple request for the city of Augusta, and that is to show me the lie. This case is about integrity, harassment, and retaliation. The city has labeled Mr. McDaniel as someone who lacks integrity, as someone who lied about Ms. Mitchell, as someone who harassed Ms. Mitchell, and as someone who retaliated against Ms. Mitchell. The city then acted on that misplaced label and terminated Mr. McDaniel. In fact, Mr. McDaniel did not lie. He is not lacking in integrity, but the so-called investigation conducted by Deborah Poole is completely lacking in integrity. The investigation focuses on all the wrongs committed by Stanley Brown against Ms. Mitchell, and then recommends that Mr. McDaniel be terminated for Mr. Brown's wrongs. In fact, Stanley Brown is mentioned in the report more times than both Mr. McDaniel and Ms. Mitchell. The investigation failed in its most important responsibility, and that is to seek the truth. Ms. Poole concluded that Mr. McDaniel was lying, not because the evidence showed he was lying, but because she believed Mr. Brown had a motive to retaliate, blamed Mr. McDaniel for being used by his supervisor, Mr. Brown, and ignored Ms. Mitchell's own admissions that she sexually harassed Mr. McDaniel. Let's take a look at what the evidence will show Mr. McDaniel alleged and what Ms. Mitchell's response to those allegations was. Mr. McDaniel alleged that Marsha Mitchell made several advances towards him. In the investigative report, she does not directly deny any of that. She says she never asked him on a date, but another employee said that she was present when Ms. Mitchell asked him to dinner. She did not ask that other employee. And in the context of her other advances, it was clearly a request for a date. That statement by Mr. Mitchell has not been disproven, was not falsified. Marsha Mitchell continued to ask Mr. McDaniel for hugs after he rejected her several times. That is sexual harassment. She did not deny that. She just said it was blown out of proportion. I don't know in what proportion it's okay to ask a fellow employee for a hug when they previously denied you several.
I can interject here at this time because opening statement is just supposed to be an opportunity for the attorneys to state what they expect the evidence to show. He's really getting into pretty much a closing argument at this time rather than stating what he expects the evidence to show. I can appreciate where you're going, but this will not be under the rules of evidence, the time to do so.
The objection is sustained. Mr. Ratley, yeah, we just did an opening statement. You will have your opportunity to present your evidence and your witnesses at that time.
I expect the evidence will show that Marsha Mitchell asked Mr. McDaniel to join her for dinner after work. I expect the evidence to show that she does not remember asking him to dinner. I expect the evidence to show another coworker overheard her ask him to dinner. I expect the evidence to show that Marshall Mitchell made a comment, or at least that Mr. McDaniel alleged that Marshall Mitchell made a comment that she wanted a sugar daddy. She does deny that statement. I expect the evidence to show that Marshall Mitchell referred to her manager, Mr. McDaniel, as Bubble Butt, not by his name, but by a bodily feature. I expect the evidence to show that she does not deny calling him Bubble Butt. She admits to it. I expect the evidence to show that she says that was blown out of proportion. I expect the evidence to show that Marshall Mitchell was accused of making sexually aggressive gestures directed at Mr. McDaniel. I also expect the evidence to show that she does not deny making those sexually aggressive gestures. These are serious allegations, and I expect the evidence to show that they were substantiated by Ms. Poole's investigation. They were not proven false by Ms. Poole's investigation. Not only was Mr. McDaniel sexually harassed, and not only did the city choose to ignore that fact, but it chose to retaliate against him for engaging in protected activity or filing an EEO complaint. Augusta chose to fire Mr. McDaniel rather than tell Ms. Mitchell to stop. Now, of course, the city says that's because he lied, and those were lies in retaliation for Mr. Brown being suspended due to something he said to Ms. Mitchell. But that's not what I expect the evidence to show their investigation revealed. The investigation revealed two things: that Mr. Brown had reason to retaliate against Miss Mitchell, and that Ms. Mitchell sexually harassed Mr. McDaniel. The city is attempting to attach Mr. Brown's motive to Mr. McDaniel and say that Mr. McDaniel is lying because of Mr. Brown's motive. Two important things the city is willfully ignoring is that Mr. McDaniel complained about Ms. Mitchell before Mr. Brown was suspended. The second and most important thing the city is ignoring is that all of his allegations were substantiated. As further evidence of retaliation against Mr. McDaniel by Ms. Poole, you will hear that she denied him access to the EEO finding.
Mr. Riley, you're going into the evidence, sir. I would limit your statement to exactly what you expect.
I expect the evidence to show that Ms. Poole further retaliated against Mr. McDaniel by denying him access to the EEO findings, and that he was only able to obtain them through an open records request. I expect the evidence to show that to be a violation of Augusta policy. I expect the evidence to show that Mr. McDaniel was denied notice of the allegations against him, that he was denied specific facts supporting those allegations. I expect the evidence to show he was denied an opportunity to respond to them. I expect the evidence to show he was denied an opportunity to confront his accusers. I expect the evidence to show the case against Mr. McDaniel is comprised completely of hearsay from witnesses the city did not bother to present to you today. I expect the evidence to show this case is based on pure speculation and conjecture and not on the evidence. The whole matter, including the case I expect the city to present to you today, is a violation of Mr. McDaniel's rights. He has a right to be free from sexual harassment in the workplace. He has a right not to be terminated for notifying the city about the sexual harassment he experienced. And he has a right to due process. Mr. McDaniel, well, I expect the evidence to show that Mr. McDaniel was harassed, lied about, and retaliated against, and it's the duty of this board to remedy that injustice without forcing Mr. McDaniel to vindicate his rights through further litigation. I look forward to proving all of this to you momentarily.
Thank you, Mr. Riley. Mr. Klein, you're on mute.
Thank you, sir.
Yes, sir.
At this time, I will call Administrator Donald. Administrator Donald, can you hear me?
Yes, ma'am.
Okay, okay, thank you, sir. I
Thank
need to administer you the oath, so if you can raise your right hand. Do you swear and or affirm that the information you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please state your full name for the record.
Odie Donald.
And are you employed by the Consolidated Government of Augusta, Georgia? And if so, in what capacity?
I am. I serve as the administrator.
And how long have you worked as the administrator of Augusta, Georgia?
A year and 2 days.
As the administrator, can you, in a nutshell, explain what your primary duties and responsibilities are?
Overseeing the day-to-day operations of the government and carrying out all policy activities of the Augusta Commission.
Okay, that was concise, thank you. With regard to Augusta's personnel policies and procedures, and more specifically, the appeals and dispute policy, can you explain for the benefit of this board what your role or the role you serve in the appeal and dispute process?
Yes, so I oversee the review, serving basically as the final authority on most decisions, with the exception of the personnel board, which serves as a final appellate. And so when there are appeals for everything related to suspensions or terminations or subsequent discipline, I have the opportunity to review the facts after they've gone through the process and either uphold, modify, or rescind actions that have taken place.
Okay. Do you recall conducting an administrative review of Marcus McDaniel's administrative appeal of his termination?
I do.
Can you recall and explain the steps you undertook in reviewing the circumstances of his termination?
Yeah, so looked at some information, most of the written statements and things related to it, as well as the letter that was given to him for his termination, as well as the rationale for which the EEO recommendation was to instruct, or I guess advise the department to move forward on the termination. So all of those documents and related information, as well as holding a review with Mr. McDaniel, as well as Parks, Recreation, and Human Resources staff.
Okay, and we're going to get into that in just a bit. I'm going to show you a document, and am I able to share, whoever is hosting, can I share a document? Okay. Thank you.
If you're sharing, I don't see it.
Okay, it's coming up. I gotta find which one. These screens are really. Okay. Oh, there it is. Okay. Can you see the document I'm sharing?
I can.
Okay, Administrator Donald, do you recall reviewing in this document, which is the Marcus McDaniel's request for appeal? Do you recall reviewing this?
Yes, ma'am.
Okay. And on the third page, I'm scrolling down to the third page and I need to, there you go. Can you see that better?
Yes.
Okay. You recall receiving, oh shucks, excuse me for that. Reviewing this, which is essentially his reason for requesting the appeal, this notarized statement. You recall receiving that?
I do.
Okay. And I want to direct your attention to the second sentence. I believe that's the second sentence of the first paragraph, wherein he writes, this action taken by management is not justified due to the fact that there is no evidence to substantiate the claim of behavior that was unethical, harassing, disrespectful, dishonest, and retaliatory. You recall that
do.
statement, sir? Okay. Now, in your role, did you also review McDaniel's job description, performance evaluations?
I did.
Okay, and if he'd had any disciplinary actions, which I don't believe, you would have reviewed that as well?
Yeah, it's in all of those things come forward as a part of the review.
Okay, and I believe you testified to this earlier, but after reviewing McDaniel's request for appeal written statement, in his personnel records, did you elect to meet with all involved parties?
Absolutely, yeah. We had I don't remember the date, but we had a meeting within the guidelines of the PPPM.
Okay. And at your administrative review hearings, prior to making a decision, what, if any, factors do you take into consideration before deciding to uphold, overturn, or modify a director's decision?
So definitely take into account all of the written documentation, but also the testimony that is provided and just whether it lines up or not, if there are any discrepancies. And, most times, as an administrator, you kind of look to the appellates or the person appealing their point of view first, because they feel as if they've been wronged by the government. So you want to make sure to give them an opportunity to speak their side and give you a breakdown of the facts, but also hear from the department at the same time.
And I'm sorry to interrupt, Ms. McLean. The host keeps muting me. I can't have that because if I need to object, I can't object if I'm muted.
I don't see you as being mute.
I just unmuted myself to say that, but I keep getting a notification that I'm being muted by the host.
Oh, okay. So if we can just not mute the attorneys, because the attorneys need to be able to make objections as needed. Thank you. And Mr. Donald, were you complete with your statement, sir? Okay. And what was your decision in the matter of Marcus McDaniel?
This one, I upheld the termination.
Okay, and you issued a letter of your findings, correct, sir?
I did.
Okay, and let me find that document. If I will share the document. Can you see my shared screen, sir?
I can.
Okay, and I'll enlarge it for the benefit of everyone. And can you state for the record what this document is?
So when a decision is when a decision is rendered, then I provide a written document to the appellant, whether it is being upheld, rescinded, or modified. And so this is the letter that was provided to Mr. McDaniel.
Okay. And I see that you recite the violations within the body of that letter, and you also give a brief synopsis of your decision.
That's right.
Okay. And do you recall the specific factors you took into consideration in arriving at your decision to uphold Marcus McDaniel's termination?
Yeah, I do. I think, the main thing was, I thought his testimony was definitely compelling. He asked some really good and thoughtful questions. So, we were able to kind of hear from both him and the department and EEO to get insights and, look at the facts a little bit more objectively. But I think the one thing that stood out to me was which was really the reason that I upheld it, is that the testimony did not align with the written statements. So the one statement is that occurred during our meeting is that there was no influence and, you know, coordination to write the complaint. But that did not align with the testimony that was written or the written statements. And so that made it very difficult, well, really impossible for me to overturn it. And so for me, that was the one factor that resulted in upholding the termination.
Okay. Thank you, sir. The board members may have questions of you and or the appellant's attorney may have a question for you.
Mr. Rattler, do you have any questions?
I do.
Yeah, go ahead, sir.
Good afternoon, good morning, Mr. Donald. There's just two things I want to talk to you about. First thing is the evidence you considered, and then the findings letter you just spoke to Ms. McLean about.
Okay.
Are you familiar with the term due process?
Yes.
And what does that mean to you?
Providing an opportunity for anyone who is, I guess, under scrutiny to be able to provide information, details, or have a fair opportunity to provide their side of the story, I guess would probably be the easiest or layman way to layman term to explain it.
And do you feel like that's what you were doing when you had that meeting with Mr. McDaniel and EEO and so forth to decide if you were going to uphold his termination?
I do, and it's actually written out that way through the 3 p.m. and provides that opportunity to all appellates. So yes.
And you said that in response to one of Ms. McLean's questions, that you gathered all involved parties. Did I hear your testimony correctly?
You did.
And who testified at that hearing?
Mr. McDaniel, as well as EEO and Parks.
Was Ms. Mitchell there?
Miss Mitchell?
Ms. Marsha Mitchell.
No,
Was a Miss Maynard there?
no,
Was Stanley Brown there?
no,
Were any of the other employees of the Bernie Ward Community Center there?
they were not.
Would they not be involved parties?
I don't think so, not in this case. And the way that the 3 p.m. allows for the review to occur, the actual appellate, I guess we'll call it in this term, is the person that is making the appeal, and they are not restricted from having anyone attend or bear witness. Whether that opportunity was asked of Mr. McDaniel, if he asked anyone else to attend, I am not aware of that, but I know that no one else was there or requested to be a part of it.
And so the testimony you received essentially came from Deborah Poole, is that correct?
Not necessarily. It came from Ms. Poole, yes, but also Mr. McDaniel and any other written statements that were provided.
And who provided the written statements?
They all come from HR, but they are provided by any of the involved parties.
Were they provided to Ms. Poole as part of her investigation?
You'd have to ask Ms. Poole that.
And can you explain, you mentioned that Mr. McDaniel's testimony contradicted one of his written statements. In what way did he contradict his written statement?
One of the written statements that were provided in general, the one that stood out to me that comes to mind immediately is that Mr. McDaniel stated that he had not been in contact or had not been advised to move forward by anyone else, but a written statement from Mr. Brown contradicted that.
It's your testimony that Mr. McDaniel said that no one advised him to file his EEO complaint?
He was not influenced by any other staff member, yes.
And I too would like to share I believe it's the same letter that Ms. McLean showed you.
Mhm.
Are you able to view that?
Yep.
And I wish my copy was as clean as hers, but is this the letter that you sent to Mr. McDaniel informing him of your findings?
And
Yes, sir.
if I can interject here, I just want to remind council that this is a public hearing and that you have now disclosed Mr. McDaniel's home address, which I redacted that information. So this is the document you have disclosed. And so this becomes a record of Augusta, Georgia. And so any member of the public is now viewing this. So just be mindful of that.
I'm okay with that. Thank
Okay,
you.
all right, okay.
And you mentioned that there is a synopsis in your letter. Is this paragraph number 3 your synopsis?
Yes.
And I'm just going to read that. When asked during your appeal review if you were encouraged to file your complaint by someone else, you responded, "No, sir." That's in quotations.
Mhm.
On the EEO complaint intake form dated March 16, 2021, you wrote, "Mr. Brown recommended I file a complaint through EEO." Did I read that correctly?
You did.
Okay, and
You
is there
did.
anything you'd like to explain about what I just read?
No, so I stated it incorrectly when you asked me, but this is the exact correspondence that I was referring to, is that when asked the question during the meeting, he said, "No, sir." But in his written statement, he said that Mr. Brown recommended he filed a complaint. So when comparing what he said versus what he wrote is the piece that gave me pause in allowing an overturn of the decision. So you're actually correct, or you actually helped to bring back the portion in which the decision was made, number 3.
And isn't it, Mr. Brown was Mr. McDaniel's supervisor, isn't that right?
Oh, I don't remember off the top of my head. So if you have those records, you might be right. I believe so, but I don't remember off the top of my head.
Is there anything inappropriate about a supervisor recommending that an employee file an EEO complaint if they believe they were harassed?
I would say no, but I think in these circumstances, it might be different. In the testimony and the conversations that were provided, I think that Mr. Brown also had some challenges with this same employee. And so for which were recognized and known within the department. And so in colluding together to address this employee, that is where the challenge is. And I think that is in the EEO report, is that there was some collusion based on a mutual disdain for this other employee. And so that is what makes it improper. On its face, without those additional details, I don't necessarily think so. I think if an employee went to a supervisor and there are none of those extenuating circumstances, it would make perfect sense to make that recommendation.
And Mr. McDaniel denied colluding with Mr. Brown, did he not?
He did.
And in that paragraph 3, you
Mhm.
say his response was, in quotes, "No, sir." Do you
Correct.
feel like that's a fair representation of his complete response?
I think so. I mean, I think there was some additional conversation, fairly long meeting, but the synopsis was no. And there were actually multiple opportunities where we discussed that, and it was basically solidified that that was his position.
And didn't Mr. McDaniel tell you in that hearing that Mr. Brown did advise him as a supervisor that he should file an EEO complaint if he felt he was sexually harassed?
I think that would be fair. I think there was a bit of contradictory information, which is my point, is that, depending on the line of questioning asked, then he was advised, and later on in the conversation, he was not. And so item number 3 represents the closing statement. So I'll give you a little bit of information that would be good for both you as well as the, I guess, the board that will make the decision. So we start off and provide an opportunity for the person asking the appeal to give a synopsis of what occurred, or they can defer and allow the department to do so. I believe in this instance, if I remember correctly, Mr. McDaniel allowed the department to speak their piece first, and then he responded with a rebuttal. And then from there, that instance and opportunity occurred at least 3 times. And so throughout the testimony that was provided, there was, again, like I said, some compelling questions and conversations, but the inconsistency led to, as before we close.
I can't hear Mr. Donald anymore. I'm not sure if I'm the only one.
Closed out, I add to the. You said what now?
You went out for me. I'm not sure if you went out for everyone else.
Yeah, you went out for me as well.
Okay, so I don't know if you want me to start over, but basically as we went through that process, probably about 3 times, there were some inconsistencies. And so as we closed out, I asked specific questions related to whether there was influence or collusion, or if anyone encouraged you to carry out these activities, et cetera, et cetera. And the answer was consistently no. And so that was opposite of what was written. And so, and it was fairly adamant. And so I took that as the consideration and allowed an opportunity to provide clarity as well as we closed out.
Mr. Donald, please listen closely, and I have a question for you.
Mm-hmm.
Allow the department to have, I guess in this instance, they would have the final comments if there are any, but.
Is that your voice, Mr. Donald?
It is.
And is that from the meeting we've been discussing?
It is.
My question to you would be, were you?
The person who said yes, sir, was that Mr. McDaniel?
I didn't hear yes, sir, but I'd imagine that's who I was speaking to.
Approached to move forward in any way in this claim, or were you encouraged to move your claim forward by Mr. Brown? Were you in any way approached to continue this process by someone who might have been negatively affected?
So let me give you some context. There's two pieces to I'm going to answer your question clearly and fully. So on February 12th, again, I have dates. On February the 1st is when, and if you look at my online claim form and my intake form, on February the 1st, I let the EEO office know that I went into the maintenance closet. Marcia came with me. Mr. Brown had instructed me to move the fogger, because to fog the building every night. So he instructed me to move the fogger.
If I can interject here for a minute, can you pause that? Counsel, can you please explain to me how you received that recording? Was that provided by Augusta, Georgia?
No, it was not provided by Augusta, Georgia.
Okay, so was Augusta, Georgia recording?
I do not know.
Well, I know the answer to that. We were not recording. Was anyone made aware that Mr. McDaniel was recording? Because I don't know. Well, did you ask your client that?
I cannot answer that without.
Because I want to remind
client privilege or confidential information.
Counsel, that it's illegal to secretly record. It is illegal to secretly record.
Georgia is a single party consent state.
He did not make anyone aware, but you go ahead, we'll deal with this later.
He does not have to. Georgia is a single party consent state, and you know that.
Excuse me.
Go ahead, Mr. McKenna.
I would tell you, I wouldn't have an issue with anything being recorded. I think he's correct. I think Georgia is a single party consent state, but what I would say is that one key thing is providing context. That was a fairly long meeting. So you have the recording. I think you would want to play all of it, especially the final portion.
And that's what I'm trying to do. I'm trying to provide context to you saying that Mr. McDaniel answered no, sir, when the line of questioning took place for over 10 minutes. No, sir is not a fair representation of what he said. And so I'm providing that context to the board. And it's my intention to enter the whole audio into evidence so the board can consider it in its entirety.
And that was going to be my next. If we're going to do that, I would ask that the entire recording be played from beginning
Most
to end.
certainly.
I think that would be fair.
And in the interest of time, I'd like to play the portion related to my question, and then I can submit the entire audio and we can listen to it together
No,
or separately,
I
but
would've-
I get to control my cross, ma'am.
Well, I object to you putting this just partly. I would ask that the entire recording be played for the benefit of the board, because they have to consider everything in context. And it's unfair to me because first, I did not know that there was a recording, and I would have accounted for in the timing of this whole process if you were going to do that. So I would object to you playing that recording in part, and I would ask that you play the entire recording of the hearing for the benefit of the board who will be making a decision in this matter.
I have no issue with playing the entirety of the recording. I have issue with being controlled on how I cross. I'd like to cross related to this question, and then the board can hear the entire recording when the time is appropriate.
Well, I'm going to object to you playing it in part, and I'll just let the chairman make the decision here.
Well, and I tend to agree. If you're going to play the recording, you need to put. We want to hear the recording, and if you want to use the recording as your, I don't object to you using the recording as it stands to your position part of the case, but you're trying to enter the recording, only a portion of the recording in for your cross now, and I don't think you would be allowed. I don't think you would be allowed to do that without introducing the entire piece. And so with that said, you would need to introduce the entire piece.
And Mr. Chairman, the rule is when I impeach a witness, which is what I'm attempting to do, show a prior inconsistent statement, I may present him with that statement. Where there is a recording, the rules require that I enter the whole piece into evidence. They do not require that I play the whole thing when impeaching the witness. For example, if a GBI lab produces a 100-page report and page 2 contains a lie, if I impeach him, I show page 2. I enter the whole report into evidence, but I don't have to read the whole 100-page report in court. That is what she's asking me to do. I'm saying let's play the portion that's relevant to the question now and enter the whole thing into evidence and play the whole thing when I finish my questioning.
And I
So
believe
all I'm asking you to do is enter it in now. Then we can then you're free to we can rule on that now.
Fair enough.
One of the board members have a question. Go ahead. You can ask your question.
Y'all hear me?
I can hear.
When Mr. Donald first started, he was asked a question about Mr. Brown and him being his supervisor. He said he don't recall that he was his supervisor. I mean, he's the administrator, he's the supervisor over everybody in the county. And if he don't know these people, how is he gonna make an adequate decision if he doesn't know if he's the supervisor of that person or not? Or maybe I heard it wrong. That's what I heard, or what I thought I heard, and I'm pretty sure that's what I heard.
Yeah, and I can answer that if you were asking that question to me.
Yes, sir, I am. Yes, sir, I am.
Yeah, so these are Parks employees, and this is not the only administrative hearing that we've had. So there's probably been a few since that time. So he asked me, was he his supervisor? I believe he was, but I don't have any paperwork in front of me. So I didn't want to confirm that and be incorrect on the record. Yeah. But during the time that we have these reviews, we have a booklet. I've got one here. I won't show you the front of it, but I create a folder which would have all of the information that I review beforehand and have it in front of me. And so today, I did not do that because I didn't want to usurp the process. And so that specific, I don't have in front of me right now, but I believe that it was his supervisor. And actually, after looking at the letter, it jogged my memory of whether that was the supervisor in question or not. Yeah. Just like I didn't remember the name.
Thing I would like to know is, if you don't know if he's a supervisor, how can you make an accurate decision?
Oh, well, at that time, I would have known if it was his supervisor, but that's a good question. Yeah.
And if it,
That's all I have. That's all I have.
That's all.
If it pleases the board, I'll start the recording. This is the entirety of the recording that I have.
Before you begin, Attorney Ratliff, can you tell us how long the recording is?
I believe it is approximately 33 minutes and 18 seconds. My intention was to play the 5 minutes that is relevant to this matter in questioning, but if everyone wants to hear the whole thing, I'm happy to listen to it again.
We found that there was sexual harassment or it was unsubstantiated. So I had a couple different conversations with Mr. McDaniel and told him that the claim was unsubstantiated, that the investigation was complete, and we did not find any findings to warrant sexual harassment.
Ms. McLean, if I may, I'd just like to note that I object to the playing of any hearsay portions of this audio. My intention was to play non-hearsay, but to the extent that I have to play the whole thing, I'm objecting to any hearsay contents.
It's your recording.
But I'm not trying to offer the whole recording. I'm trying to offer the non-hearsay portions.
We want it played. Thank you, sir.
But we investigate and we will come back with recommendations for his termination, correct?
Right. And I did tell him that as well, but we don't release our whole report of findings. You know, that can be obtained through open records requests. So I did tell him that as well, that yes, we did recommend termination, but again, we aren't the decision makers. We make the recommendations in the compliance department, and then we're pretty much out of it at that point.
Any insights related to that piece that you are able to share as far as notification and things of that nature?
This is the first time hearing of this. Mr. McDaniel's recitation of the policy is correct. However, this piece of information is the first time I'm hearing this. I'm going to I'll about that right now.
Understand. We'll continue. Go ahead, Mr. McDaniel, so finish your rebuttal, so we're making sure to note the notification piece that you just highlighted.
Yes, sir. Thank you. Let me get my notes together here. So again, I want to reiterate that some of the generalities that Ms. Poole is making, she's using such words like a lot of and we spoke with witnesses and certain employees. So I have facts that point to the truths in this matter. So I just want to review my initial appeal, if that's okay. So on February 1st, 2021, I was sexually harassed by Marcia Mitchell. I filed an EEO complaint and I was unjustly terminated for violating EV2 and EV14 of Augusta, Georgia's Personnel Policies and Procedures Manual. This action taken by management is not justified due to the fact that there is no evidence to substantiate the claim of behavior that was unethical, harassing, disrespectful, dishonest, nor retaliatory. And I'm going to focus on the retaliatory point in a second, which is in direct conflict with my personal work ethic and history. Termination, and I'll get to that as well. Termination is unwarranted, and the actions taken by management are not in accordance with, and I read that section already. So I mentioned to you already, at the time of the appeal request, I had never received any findings. So I'll get back to my original appeal in a second. So I mentioned to you that I paid out of my own pocket for the findings that Ms. Poole and the EEO office were supposed to give to me.
Jeff here, Administrator Donald, I apologize. I believe what he's saying when he says he paid, Mr. McDaniel, you have an open records request, correct?
I sure did.
Okay, all right. So
I understood what he was saying there. My questions were around his notification. He was notified verbally or not provided in writing.
Correct.
Results, the findings, as well as the recommendations for his termination, as those things were given verbally, with adding the insight for him to be able to rebut, prepare, and appeal for. And so, end around that. And so,
I'm sorry.
Before you move on, have you received to date the results of the open records request?
Yes, sir.
You have?
Yes.
So you now have the full bit of information related to EEO's findings that recommended your termination?
Yes, sir. I have what the Augusta Law Department sent to me. Yes, sir.
All right, got it.
So to your point, at the date of my termination, on August the 2nd, in my office with Mr. McDowell, during my termination, once he let me know that I was essentially being terminated, I spoke it out loud and asked the question. I said, weren't they meant to contact me? So they're saying they did an investigation, but EEO never contacted me in regards to the findings. So there was a split. Go ahead.
Well, I understand that. I would just, and because I don't want to belabor that point,
Okay, I'm sorry.
I have that understanding, and you know, maybe that was supposed to occur.
Yeah.
But my question is, because at this point you do have all of that information, for me, what would be helpful is more of a dispute on those findings of fact.
Okay.
So if you now have it and you are saying that their review is not factual or it is not appropriate,
Yes,
then that is what I would listen to, because now you have received it.
correct.
And so that's where the issue would be. So let's proceed in that manner.
So I'm going to read a statement from the findings from EEO, and it talks about the summary of recommendations. Based on the information obtained, I'm reading this verbatim. Based on the information obtained during this investigation, the EEO claim filed by Mr. McDaniel was in direct retaliation to the disciplinary action received by Mr. Brown and was a false claim. So I want to break that statement down. So into two parts. The first part is The EEO claim filed by Mr. McDaniel was in direct retaliation to the disciplinary action received by Mr. Brown. My dispute to that is two claims. First thing in the question is the disciplinary action received by Mr. Brown occurred on March the 8th. Okay, March the 8th. And I made my initial online claim on February the 12th. There's two forms you can complete. You can do an online form, and then there's an intake form that Ms. Poole sends to you. And she sent that to me, and I got that information, and I filled that out later on, and I can confirm those points as well, and better rebut those. But in the moment, they're claiming that my claim was in direct retaliation to the disciplinary action received by Mr. Brown. Again, Mr. Brown did not receive his disciplinary action until March the 8th. My original online claim was filed on AugustaGA.gov on February the 12th, nearly a month before. So I was already in communication with the EEO office before that. So that does not make sense. How can I be in direct retaliation to Mr. Brown's disciplinary action if his disciplinary action was not received by him until almost a month later after my original claim? How does that make sense?
Mr. McDonald, would you like me to give you any information?
Just if you guys have rebuttals, just make sure you take your notes and respond appropriately to his full response. Continue.
Thank you, sir. Thank you, sir. So and also with that, and Ms. Poole can corroborate that. She can corroborate the statement that I just made, because after my original claim, we were in contact after that, and it's in the findings. In the findings that I received, in those findings, it discusses how Ms. Poole had followed up with me a couple of times, at least twice, before Mr. Brown received his disciplinary action the following month. Ms. Poole had already, she was already in contact with me via telephone.
Okay.
And via email, but she followed up via phone at least twice, and letting me know, well, just asking, doing her due diligence in regards to seeing this claim through, in the sense of making sure that I get the proper paperwork in. Right? We handled that part. Marriage received by Mr. Brown. Boom. So the question still remains: how is that in direct retaliation to Mr. Brown's disciplinary action when that was already?
We got that point. I want to make sure that we capture. Is that your main rebuttal on the EEO report?
That's the bottom line. There's a lot of rebuttals, but I will say that that's the bottom line as far as their claim of retaliation, which is unsubstantiated. To add to that, although that's the bottom line, I also want to add to that the nature of her follow-ups with me were to find out if I wanted to continue with the original claim that I filed, an online claim that I filed on February the 12th. I told her yes, but based on my experience with Marcia, I began to think that certain more things would begin to happen. So that was based on my experience, not based on anybody else's opinion, but my experience with her at work. And I let Ms. Poole know this. I said, I think more things are going to happen, so I'm going to take notes, because I understand the nature of this claim. This is a strong claim that I made as far as sexual harassment, and I don't take it lightly. So therefore, it makes sense to substantiate it, to let those who are supposed to investigate, to let them know that this is not a one-off statement. There's a bottom line, but then there's several things that have happened, several things that have continued to happen. So I let Ms. Poole know, I said, yes, I still want to file. So the EEO office knew my intent from the beginning. They knew what I had intended to do as far as filing a claim. That was clear. So she let me know that was fine, and she did encourage me to get it in. She did encourage me to go ahead and get it, and I said, I will. I believe I'm getting more, I'm collecting it, taking more notes. So when I submit it, it's correct. So my bottom line with that is there was communication between the EEO office and I before Mr. Brown received his disciplinary action. I wanted to make that clear.
Oh, yeah, you can check in now. I think the question was, one, he provided an online form for which he started a claim of sexual harassment. And so his rebuttal is that there were updates to EEO that he intended to not only continue his claim, but that he was actively taking notes to strengthen his case, and that he notified EEO of that. Because his rebuttal appears that he believes he started a claim early, and it currently, or when it was submitted, it is completely unrelated to the other staff members' discipline. So this primary rebuttal, does EEO take a separate position in that?
Yes, we do, Administrator Donald. The casework came in our database on February the 12th.
Okay.
What I always do at that point is review it, contact the employee, get out, if it looks like there is a case, get out our second round of paperwork, which includes our affidavit and all of our other information. I always let the employees know we can't kick off an official investigation until I get that second round of paperwork back. So in the meantime, I'm going to be following up with an employee. I would email and I would call Mr. McDaniel and ask him if he was going forward with the case. He said that he was, but he was still collecting information. So each time I said, go ahead, get your paperwork in so I can get this investigation kicked off. You can add to your case at any time. You can keep submitting additional information to me. But I encourage him, we need to go ahead and get this where we can get a letter sent out and kick off an official investigation. And it was strange because I'm not really have one happen like that, where it was just, well, I'm going to do it later, but I'm still trying to get more facts. So again, I'm like, let's just go ahead, let's do what we turn in what we've got so we can go ahead, start moving on it. And then all of this, after there was the disciplinary action from Mr. Brown, then all of the additional paperwork came in. And that's also when employees were substantiating, that they heard the conversation that it was retaliatory and that he was waiting. It was after the disciplinary action, the suspension, that they decided to go ahead and move forward.
Mr. McDaniel.
Yes, sir.
Through this information, do you have any other closing comments that you would want to provide?
Yes, sir. So am I allowed to still rebuttal to her statement?
I mean, you can closing statements or rebuttal. Are there any other items that you want to present at this time? This is the time to do so.
Yes, sir. So to her statement, she mentioned all of a sudden, as if this was the first time that this had been mentioned to her in her office. And it's interesting that she finds it strange, or that the EEO office that she finds it strange that I would turn it in after Mr. Brown received his disciplinary action, when I don't understand how you find that strange when I spoke to you a month prior and you knew my intent. That does not make sense. do you find it strange when I told you what my intent was from the beginning? I understand he happened to receive his disciplinary act.
I'm sorry, did I see one of the board members raising a hand? I didn't want to continue if someone was trying to say something.
Yes,
Unless I missed something, you said you were gonna take 5 minutes of this. And we've said, I know it's been at least 15 minutes.
Yes, sir.
Since
My intention was to play about
No,
5
sir,
minutes.
Mr. I'll answer that. Mr. Atkins, the appellate's counsel wants to use the portion of the recording. For him to use the portion of the recording, we have to hear the whole recording. So, and he's going to use that. I don't object to him using the recording. So, we're going to hear the recording as an entirety. Counsel, you can go ahead, continue.
During that time frame, but his disciplinary action has nothing to do with my original claim. And by the way, that was never responded to or never handled. And the investigation was never completed. There are dates in my original online claim form, and I have it here. My original online claim form. She let you know that she received my information on February the 12th. There's several dates that I turned in for my information and the statements that I made. February the 12th, I made my original online claim, sent it to the EEO office. February the 15th, I sent it to at the time, my supervisor, and he never responded to my claim. James Rouse, I sent it to him. He never responded to my claim, and I sent him a statement in response to Mr. McDowell's instruction to me to get statements to Mr. Rouse about a separate incident. But nonetheless, I still sent it to Mr. Rouse and he never replied. In the findings, on March the 16th, when I turned in the intake form, the intake form just kicks off the investigation. It doesn't mean that they're not aware of my statements. On March the 16th, turned in my intake form that Ms. Poole is referring to that allows them to kick off their investigation, and she kicked off the investigation on March the 26th. Now, the interesting part is, if they're calling it retaliation, retaliation does not make even common sense, respectfully, even common sense, when my statements are consistent on each date. My original statement on the 12th, several statements. Those same statements you can find in my email to Mr. Riles on February 15th. Same statements, they never changed. Same statements are in the intake form that I sent to Ms. Poole. They're all the same. My story never changed. But somehow, down the line, my investigation, as my findings will show, my investigation, or their recommendation, their findings had more to do, interestingly, with Mr. Brown than it did with my statements. It's my claim. Mr. Brown has nothing to do with my statement that I made on February the 12th, period. Nothing. I made my own statements. Now, as far as witnesses saying that, what Ms. Poole just said, she said, I had witnesses say that they heard the conversation of retaliation. It's the same thing. How do I retaliate to something that nothing has happened to me? So my question to you all would be, what am I retaliating against? Why would I retaliate for someone else? Why would I risk my job for that?
As we close this out, Now the department to have, I guess in this instance, they would have the finances if there are any, but my question to you would be, were you approached to move forward in any way in this claim, or were you encouraged to move your claim forward by Mr. Brown? And were you in any way approached to continue this process by someone who might have been negatively affected?
So let me give you some context. There's two pieces to I'm going to answer your question clearly and fully. So on February 12th, again, I have dates. On February the 1st is when, and if you look at my online claim form and my intake form, on February the 1st, I let the EEO office know that into the maintenance closet, Marcia came with me. Mr. Brown had instructed me to move the fogger, because fog the building every night. So he instructed me to move the fogger. I go into the maintenance closet. Marcia comes with me. And once we get in there, she moves her hips in a way, basically like, I don't want to demo, but I don't want to read, but I don't want to go back through the claim though. I actually have all of the information, your statement, their statements. Okay.
My question remains the same. Were you approached and encouraged to continue your claim by someone other than you?
To continue it? No. I chose to continue it on my own.
Okay. Found it initially.
Correct.
You were encouraged by someone else to file it initially?
No, that's not.
So at no time.
No, sir, that's not what I'm saying. No, sir. I don't mean to cut you off, but no, sir. What I'm saying is, I chose to initiate the contact with EEO office. That was my decision.
Just give me a yes or no on this. Whenever you filed the first and the second time, were you encouraged to file at any time? Were you encouraged to file your EEO complaint by someone else?
No.
Outside of EEO?
No, sir.
So you fully and independently filed these claims on your own, and you did not collude in any, or even been approached in colluding in any form or fashion by someone else?
Correct. I did not. Correct. I did make my own choice.
Got it. EEO, any final related to this? What do you want, sir?
So to your point, I just want to clarify something, just to be clear. Now, the choice was solely mine to file this because my coworkers actually encouraged me not to do it. Ms. Maynard and Mr. Brown, they both told me don't do, on a personal level, they said, don't do it. Don't do it. They both told me this, they said, don't do it because what they're going to do is flip it. They're going to try to attach Mr. Brown to it because he said that's been his experience. Unfortunately, I chose to go ahead and go forward with it because Mr. Brown's not responsible for my job. Ms. Maynard's not responsible for my job. And I felt the need to document it. On me, that's not on anyone else. I have that choice. I made up in my own mind. Now, as a professional, on February 1st, the day it happened, I didn't initially even mention. They knew something was wrong because when I came back up that hallway, you could have seen it on the camera. When I came back up the hallway, Ms. Maynard asked me. She said, "Marcus, what's wrong?" So they knew something was wrong. It's not as if I was, just abruptly keeping secrets or not just looking weird. Ms. Maynard asked me, "What's wrong?" And Mr. Brown asked me the same thing. He asked me, "What's going on?" I turned to Marcia. I said, "Marcia, tell him what you did." And she pauses and didn't say anything. I said, well, tell him what you did. Her words were, unfortunately, this part isn't documented, but her words were, well, he's a grown ass man. Those are her words. I don't mean any harm, but those are her words. So on a professional level after that, because I didn't tell anyone what happened. On a professional level, Mr. Brown said, okay, since you're not telling me what happened, and that's your right, that's okay. If something serious happened, you have the right to file with EEO. I never filed with done this kind of claim before, so that's new information to me. He told me you have the right. He never encouraged me, but he told as a supervisor to subordinate, he let me know. He said you have a right to file a claim. You don't have to mention. You don't have to tell me anything. And that's already what I was doing. I didn't say anything to him. But he said, you have the right to file. He told me that as a supervisor. But on a personal level, he told me not to because they're going to flip it on him. And as you can see, that's exactly what happened. So I take responsibility for filing the claim. And Ms. Maynard told me the same thing. I saw her text messages. She's saying that she's texting somebody at the administrative office that I'm trying to retaliate, which is nonsense because there's nothing to retaliate to. Something happened to me. That's why I made my original claim. That doesn't make sense. How am I retaliating if nothing happened? If I didn't get a disciplinary action towards me, I didn't get written up. Mr. Brown's situation had nothing to do with me. And I'm mentioning Mr. Brown because they fired us together. How do I turn in a claim and we get fired together? My claim had nothing to do with Mr. Brown. It had everything to do with what happened to me in that closet with Marcia and other things that she said and other things that I witnessed and other things she said to me. And her approaches to me. So
HR and EEO, are there any additional comments related?
Probably I would like to add, Mr. Brown did tell me in his interview that he did encourage Mr. McDaniel to file a claim. He said his disciplinary actions never get accepted by HR, and if he tried to pursue it, nothing would happen. So he did say he encouraged him to file the claim. And in regards to sending out emails and Mr. Riles and some people not responding, I kept telling Mr. McDaniel once it was turned over to EEO to quit copying everybody on emails, people in HR, Director McDowell, Mr. Riles, that it was just between us at this point, and we didn't want this information going out to other people in the city and other departments at that time.
Mr. Dunn, may I rebuttal?
No, sir.
Yes, sir.
We talked about you had to find a rebuttal.
Yes, sir.
Certainly, you guys could rebut. Period. I would say for me, the findings of fact that I have to make a decision on and review.
Yes, sir.
Is one whether because I believe that you may have a conflicting testimony than someone else, and so we have to identify whether that is accurate or not.
Yes, sir.
The second piece is whether your claim, which you identified as occurring first and being followed through on later without any other input, if that is as accurate as what is in the paperwork. And so I will now review those findings of fact. I will read there a couple of days before we have to provide and render a decision, but we will definitely do so within the guidelines of the 3 p.m. considering these your testimony today or your responses today, as well as those of EEO. I will say the second thing is that regardless of the decision that I render, or at least if the termination is upheld, not the final say in that instance.
Yes, sir.
In the instance there, you do have an additional level that you can pursue, and of course, my decision whether it is to affirm the recommendations of EEO or if it is to change those, the next step would be included in the written decision that is rendered. Yes, sir. So I appreciate your time.
Oh, thank you. Thank you for listening to me today. I thoroughly appreciate it.
Absolutely, and we will we'll make sure to render the decision within the guidelines of the 3 p.m. Which I've got to review now and render that decision. And again, regardless of what the decision is, if there are any steps, I believe if the decision is modified in any way, it becomes final and there is no additional appeal. But if it is affirmed, then there is an additional step with the review board. Again, we'll make sure to include that in the letter. We'll make it clear. I don't want any confusion around what your options are. You should be able to look at them fully throughout the process. Yes, sir.
Yes, sir.
Well, I appreciate your time today, sir.
I appreciate your time. And now, I know we're about to go. May I say one more thing? Okay. No, it's okay. I don't have a problem with that. So just thought I'd ask. Thank you.
Yeah. All right.
All right.
Thank you very much.
Thank you.
Okay. Mr. Donald, he said a lot more than no, sir, did he not?
He did. I think I alluded to early on, he had some very compelling testimony. But the key is that when asked, because not only did he say no, sir, as I mentioned, when I asked for the no, he gave an extremely firm no, that there was no influence. It was solely his decision and there was no additional input. Further, that he was actually advised not to do it personally. But the piece that, again, made me feel as if the decision had to be upheld was that the testimony from the person for which he had said he had not received that advisement actually said that he did advise him because his terminations were not there. And so that was the testimony that was provided by EEO. And so with the conflicting testimony from Mr. Mitchell, but the constant testimony from EEO, from my purview, there was no choice but to uphold it. But since, as you see in that long audio, there was a lot of conversation. And so if I was to reduce that, then he kind of gets a full negative piece. But if I move forward in the way that I did, he also has this form. And so I thought that the most appropriate process.
But didn't he say that Mr. Brown advised him on a personal level not to do it, but on a professional level, he said, as your supervisor, I have to advise you that if something serious happened, you have a right to file a claim.
That is correct.
And isn't that consistent with what Mr. McDaniel said on his form?
I don't interpret it that way. Again, not only do I look at the form, look at the actual in-person testimony as well. And the in-person testimony had conflicts with the form as well as the testimony given. And so with that being said, the consistent testimony that was received, as well as the documents, which I think we alluded to were provided during an open records request, came from EEO. And so again, that is why it was upheld.
And you said testimony from EEO. You didn't hear from Mr. Brown, did you?
No, I heard from the EEO officer. I did not hear from Mr. Brown during this particular hearing, correct?
So Mr. Brown didn't tell you I recommended he file one. EEO told you, they told EEO he recommended that.
That is correct. It was in the EEO report, correct.
But you did not hear that from Mr. Brown.
I did not hear that from Mr. Brown during this testimony, correct.
Did you hear it directly from Mr. Brown during any testimony in regards to Mr. McDaniel's case?
Not in regards to Mr. McDaniel's case, no, but Mr. Brown had a case as well.
I have no further questions for this witness at this time.
I do have a couple of follow-up questions for the administrator. Chairman Barbie, if that's permitted. Administrator Donald, you recall writing a letter to Mr. McDaniel on August 12th of this year, informing him of the date of his administrative review hearing?
Yes, those are before, yes.
Yeah, okay. And in that letter, you remind Mr. McDaniel that although it's not outlined, I believe, is what you said, in the 3 p.m., that he is entitled and can have an attorney present. Is that correct?
Yes, absolutely. Yeah, that's a part of the record. I mean, you're able to do that, yeah.
Okay. And if he had hired an attorney, would he also have had the opportunity to have that attorney call witnesses to testify on his behalf?
And not object on the grounds of relevance. Augusta has the burden of proving he should be fired. He doesn't have the burden of proving he shouldn't be.
Well, this is just a follow-up to you're making a big deal of witnesses not testifying or whatever, what have you. And so I'm pointing out that he also had the ability to have an attorney present and to call his own witnesses.
But he has no burden.
Well, it's open, okay?
The objection's noted. The objection's noted. You can move.
Administrator Donald, if you would like to respond. I think I cut you off.
So yes, you can have witnesses as well as your attorney present, and folks do exercise that as they please, yes.
Okay, thank you, Administrator Donald. No further
Mr. Donald, I have one further question.
Yes, sir.
What lie did you determine that Mr. Mitchell told about, I'm sorry, what lie did you determine Mr. McDaniel told about Ms. Mitchell?
I'm not following what you're asking. You're talking about related to the sexual harassment?
Well, he's accused of lying about Ms. Mitchell. What lie did he tell?
Well, so that is not I don't think the result of my response or my decision. So my decision is either to uphold, modify, or rescind. Because of the inconsistencies related to the testimony, and the confirmation, at least from my purview and from what you just heard, I was unable to modify or rescind the termination, and so I upheld it.
In upholding it, you made a finding of fact. There's violation EV-2, which is for falsification or misrepresentation of official document or record. EV-14, violation of Augusta, Georgia's discrimination and or unlawful harassment policies.
Mm-hmm.
He's accused of violating those policies by telling a lie about Ms. Mitchell. I'm asking a simple question. What lie did he tell about Ms. Mitchell?
And again, while he is based on Ms. Mitchell, it is the falsifying of the actual EEO complaint. And so if you were encouraged and colluded to provide a false EEO complaint in collusion with someone else who was negatively impacted, then that would mean you have provided false testimony through your EEO complaint. And so from my perspective, if you colluded to deliver an EEO complaint that is not accurate as proven by our EEO office, then I have no choice but to uphold. And so from my perspective, if you colluded to deliver the EEO complaint, then it on its face is false. And so that is why, again, that was my decision. And so it may not be a particular lie, or it may be a series of lies, but it is more so the EEO complaint itself is pushed forward in collaboration with someone else. And so that is that finding of fact is what it's referring to.
I could be mishearing you, but it sounds like you did not identify a lie in what Mr. McDaniel said.
Or is that it was a series of them?
What? Tell us what they were. I just want to know what the lie is.
Objection. The witness has answered his question.
He's answered the question, Counselor. We can move on.
I didn't hear an answer, but if y'all did, I'm fair enough.
Okay. Anything further?
Nothing for me.
Okay. All right. Counselor, go ahead and proceed with your next witness. Ms. McLean?
Am I frozen?
There we go.
Hello.
Yeah, go ahead. Yeah,
Is that-
you're fine. Go ahead and proceed with your next witness. Yes, ma'am.
Okay, I didn't hear what was said. It froze on my end. Did the board members have any questions of Administrator Donald? Can you hear me? It's frozen again.
I don't think so.
I can hear you. Okay.
Oh, okay. If there are no questions from the board members,
I'd like to move. Yeah, I'd like to move on.
okay, all right. Thank you, Administrator Donald.
Thank
I have no further questions of you.
So I'm free to log off, right?
Yes, sir.
Yes, sir.
Thank you.
Thanks, sir.
I'll now call Deborah Poole. Good morning.
Good morning.
Okay, can you hear me clearly?
Yes, I can.
Okay, can you please state your full name for the record?
It is Deborah Ellen Poole.
Okay, and where are you employed?
I'm employed with the City of Augusta.
And in what capacity?
I am the EEO coordinator in the compliance department.
Okay, and as the EEO coordinator, can you explain what your primary duties and responsibilities are?
Yes, anytime someone contacts us about a potential EEO claim, I'll meet with them. We'll decide if they're wanting to do paperwork, if they're wanting to go forward with a claim, if they want to try to work through something with mediation. Often it may turn out the claim isn't a Title VII issue or protected category. So then I'll work with Human Resources to refer it to them. So it's really meeting with employees, conducting investigations, coming up with recommendations, as well as doing training ongoing for sexual harassment, various other issues, trying to be proactive. I'll do things such as the EEO-4, our government reporting, and various things of that nature.
Okay, and Ms. Poole, how long have you worked as the EEO coordinator for Augusta, Georgia?
For 1 year and 8 months.
Okay, and for the benefit of the board, can you provide a brief synopsis of your educational background and work experience? And with regard to your work experience, ma'am, please provide information regarding any specialized training and or certifications you may have received.
Certainly. I have an undergraduate degree from West Virginia University as an accountant, and I was a CPA. Then I went on to get a master's from there in industrial and labor relations. I have over 15 plus years of experience in the field of human resources, in all of the different gamuts of human resources, mostly focusing on employee relations and EEO issues. I've had my SHRM certification. Just this past year, I've had training as an EEOC investigator, training on mediations, training on EEOC sexual harassment, training on LGBTQ discrimination, training on ethics and law and employment law. With my years of experience, I've worked for companies such as Capital One, American Tobacco, BMW Manufacturing Corporation, again, all in the same capacity or similar.
Oh, well, thank you for that. Are you familiar with Marcus McDaniel?
I am.
Okay, and how did you receive notice of the complaint he filed against Marcia Mitchell?
Yes, I have a database that I check daily to see if we have any complaints filed. And there was a complaint filed on February the 12th. It's an initial complaint that was in our system. And I understand at that same time, they were working with Marcia in Human Resources. She had written a statement and was filing a complaint. I believe she wrote a statement on 210.
Okay.
And something had happened in the weight room involving Mr. Brown, Mr. McDaniel, and her.
Okay, I didn't mean to interrupt you, but we'll get into the timeline of all of this. But can you please explain how your office receives complaints of discrimination or harassment now?
It can be like his initial complaint came through the database that we check, or it can just be someone calling me or emailing me, and then I'll set up for them to come in for a meeting if they would like to. I can email paperwork to them. So there's a number of different avenues of how someone can kick off a claim. What happens when it goes in CityWorks, I reach out to the employee, and get some more information from them.
Okay, let me stop you there, ma'am. Can you explain for the benefit of this board what CityWorks is?
Yes, sorry. That is our database where I will see, like Mr. McDaniel did put a claim in for sexual harassment against Marcia Mitchell. So when I contacted him, then sent all of our forms to him, because that's going to include honesty code, confidentiality, permission to investigate, affidavit, all of that information that was sent to him.
I'm going to stop you right here because at this time I'm going to share a document as you're explaining that process. If you can just be a little patient here. Let me find where it is here. Maybe this is. Just 1 second here. Apologize, okay. This is share this document. Okay. Can everyone see that document? Let me blow it up. Okay. And Ms. Poole, I've shared a document with you. Can you explain to the board what this document is?
This would be actual paperwork where we could be kicking off a formal investigation where they're going to put down their complaint, who it is against, what the issues are, what type of discrimination it is. If there are any witnesses, et cetera, then there's going to be additional forms that would go out with that. Again, that's going to include what our honesty code is, confidentiality, how we can have permission to investigate, as well as an affidavit that's signed.
Okay, and would this be the form you received in CityWorks?
No, that is a form. In CityWorks, it's very basic information.
Okay.
And that would be, I sent an email to him on 2/17, which I included all of those documents. So they were emailed to him. Then he completed and returned them to me on 3/16.
Okay, so this date, I don't know if you see my cursor up there in the top right hand. That is March 16th, 2021. That would have been the date that his complaint became official?
Correct, because on 2/17, it went into the database.
Okay.
And from that time on, I was following up with email or phone conversations, asking him to get his paperwork into me so I could go ahead and kick off the formal investigation.
Okay, let me stop you there, ma'am, because we'll get into all of that. I see that if I'm strolling down on page 1 of this document, the X's represent this, what categories he's making a complaint?
Correct.
Okay, and he indicated sexual harassment and harassment. Is that correct?
That is correct.
Okay, I want to stroll down to the second page. I think it gets him to state his complaint, correct? This is where the applicant would reveal the reasons for his complaint, correct?
Correct.
And he writes here that Marcia Mitchell made several advances toward him, that she consistently asked him for hugs, that even after being denied, she continued with her unwanted request, and that she asked him out for dinner in a hugs. Is that correct?
That is correct.
Okay. And he made some other statements there that she said she wanted a sugar daddy. So that is the gist of his complaint right
Correct.
there. And would these issues be issues that you would investigate?
That is correct.
Okay. And any other issues that may flow from that, these particular areas, you would investigate that too as well, ma'am?
Correct. As we call in witnesses, other information may come out, different things that we need to investigate. So we never know exactly, what angle it's going to take or where it's going to go, but we're going to look at everything in the entirety.
Okay, I want to direct your attention to question the item number 3. And the question is, what evidence do you have that supports your complaint? And he wrote, witnesses, my supervisor can verify my statement. Is that the only evidence he indicated that he had, that his supervisor?
Yes.
Okay.
I object as an improper characterization of the evidence.
I'm asking.
Witnesses, period, my supervisor can verify my statements. That's 2 separate entries. That's an improper characterization of what she just read.
Witnesses, did he name any witnesses, Ms. Poole? On this document, did he give names of witnesses?
I don't believe he did. If you can let me, I would have to look back at the whole document. I know he talked about who his supervisor was, but I don't believe that he did.
Okay, and I'm going to, as you look for that, I'm going to scroll down to item number 4. And the question is, have you discussed your concerns with management or a supervisor? He indicated yes. And to whom did he speak? He indicated Stan Brown. Is that correct?
That is correct.
Okay, and within that, he said that he spoke to Stan Brown multiple occasions from 1/21 to 3/21, and that Mr. Brown instructed Marcia Mitchell to leave him alone, and that Mr. Brown recommended that he file a complaint through EEO. Is that correct?
That is correct.
Okay, he further stated that Mr. Brown was careful not to say too much because they didn't approve of his write-ups. Is that correct?
That is correct.
Okay, and that Mr. Brown felt like she, and I guess he was referring to Marcia Mitchell, was sent there to cause trouble in the first place. Is that correct?
That is correct.
Okay. Also, he listed James Ryle, and James Riles was the recreation district manager, correct?
Correct.
And Mr. Riles instructed, he says that Mr. Riles instructed him to submit a statement on a conversation between Mr. Brown and Miss Mitchell, and that there was no response at all. Is that what he writes there? And
yes, ma'am. Yes.
Okay. And that he's indicating that his supervisors responded to Marcia's complaint swiftly, yet have not responded to his.
Correct.
You mentioned in your testimony something about confidentiality and honesty code.
Correct.
And I'm scrolling down to this page, and I do believe the honesty code is mentioned, confidentiality statement, which Marcus McDaniels acknowledges, correct?
Correct.
Okay, and can you briefly explain what the purpose of this confidentiality, him acknowledging that, why is he asked to sign this confidentiality agreement and what's contained therein?
Yes, anytime we have the complainant, respondent, witnesses, anyone coming to our office, they're going to sign this confidentiality agreement. And the reason for that is we want to protect everyone's rights. We don't want information being talked about in the department. It's going to taint our investigation when everybody's having hearsay or adding to information. And once it's turned over to us, management's no longer involved with it in the department at that point in time. We're trying to conduct an impartial, thorough investigation based on the facts, the information that we can get from any person that may be able to share any information. And the confidentiality is huge because, again, we just can't have it being discussed, and it's going to, in the end, can mess up the results of the report and what we find.
Okay. And also included within this packet, this is the complaint that he or any complainant receives, and they receive information relative to the confidentiality section of the 3 PM, which is Augusta's Personnel Policy and Procedures Manual, as well as the Honesty Code.
Correct.
Correct? Okay.
That is correct.
And for the benefit of this board, can you explain what the Honesty Code is, please?
Yes, with the Honesty Code, we're just saying you need to give us honest, accurate information when you give a statement, and that it shouldn't be exaggerated. There shouldn't be things that are falsified, and there can be termination, any type of disciplinary action if we find that is the case.
Okay. Now, in this last document, that's not included. This is his acknowledgement of receipt of the Personnel Policy and Procedure Manual, which I don't believe this is included in the complaint form. I think I just attached that to this document. Okay, so Ms. Poole, you conducted an investigation of Mr. McDaniel's complaint, correct? Now,
Correct.
you were talking, a lot has been made of Miss Marcia Mitchell. You're familiar with Marcia Mitchell?
I am. I've met with her numerous times and talked to her on the phone, sent emails.
Okay. And let's talk about the timeline of all of this so that the board can get a complete understanding of what took place in the context of your investigation, how all of these individuals line up together so that they can get a good picture of what is happening here and how you put everything together to make a recommendation in the end, okay? To get to arrive at your findings. So let's, if you will, if you can provide this board a timeline, if you can do such. Okay.
I can.
Okay. All right.
Okay.
So
again, on 2/10, Marcia Mitchell wrote a statement within her department about feeling like she was in a hostile environment, I believe it was, or that she was being harassed in her department. It wasn't falling with us in EEO, and it was being handled by Human Resources.
Okay, so what can you tell the board what department Marcia Mitchell worked in?
Marcia Mitchell was with the Parks and Recreation Department.
Okay, and do you recall who her supervisor was at the time?
Her supervisor was Stan Brown, and then when he changed locations, or I believe he changed his hours, it became Marcus McDaniel.
Okay, all right, so go ahead, ma'am.
So then in 2/12, as we stated, is when Mr. McDaniel put his online information in the database. Forms were sent out to him by me via email on 2/17. I would continue to follow up with him, encouraging him, go ahead, get your paperwork in. He said he was still taking notes. And I said, go ahead, get the paperwork in. You can always add to it. You can continue to give me additional information, but I want us to go ahead and get the case kicked off. And each time I spoke to him or would email, he said, yeah, I'm still going to do it. I'm just still compiling my notes. And again, I would encourage him, go ahead and get what you can to me, get the paperwork in so I can start my investigation. Then on 3/10 was when Mr. Brown was suspended for 7 days. I believe it was 3/10 or 3/11, maybe, when it was supposed to start.
Okay,
So
and Mr. Brown was suspended in connection with Marcia Mitchell's complaint?
Yes, he was. From what happened, that Human Resources handled the conversation that was in the weight room with Marcia Mitchell, Mr. Brown, and Mr. McDaniel.
Okay,
So
and
that
just
is,
to be, okay, sorry to cut you off. Just to be clear, you did not investigate that particular complaint, is what you're saying?
that is correct. That was a grievance and was handled through Human Resources.
Okay, all right, thank you.
Mhm. Then on 3/15, when I spoke to Mr. McDaniel again, he said he wanted to move forward. So I reiterated the urgency of handling the situation and that we needed the paperwork as soon as possible. On 3/16, he did turn in his paperwork and met with me.
Okay,
that-
I'm going to stop you there. Do you recall the dates of Mr. Stanley Brown's suspension from the department?
Originally, I believe it was supposed to be like 3/11 through 3/19, but I know he was appealing. So again, that was Human Resources. So I don't know the exact dates that he did his suspension.
Okay.
It was around that time frame.
Mhm.
So then I just went through our normal process where I sent out a letter that was 3/25. I sent a letter to Marcus saying we're commencing a complete investigation. I sent a letter to Marcia Mitchell, letting her know the complaint was filed against her. Of course, copied legal, the administrator, the department director, my director, that this was happening. Then I find out a few days after that, 3/31, I met with her because the respondent always gets the opportunity to read the statements, what has been alleged, and then they get to write their response.
And the respondent is Marcia Mitchell, correct?
Yes,
Okay.
that's correct. And so I met with her to give her the opportunity to write her statement. So we did that. And then on 4/5, there were some text messages that were emailed to me that was conversations between
Objection as a
two
hearsay.
employees.
And this, you received this in the course of your investigation, correct?
Yes, I did.
Okay, and it became those text messages became part of the evidence you submitted along with your report, correct?
That is correct.
And those text messages were also included or would have been included in any information that Mr. McDaniel received as part of his open records request, correct?
I sent them, to the legal department. I don't know, you all then make the final decision on what would go out.
Oh, okay, I apologize for that. Let me share with you, if you would. Let's see, hold on one second. Okay. So did you meet with the individuals, the text messages? Whose text messages are you referring to?
Yes, it was text messages between Felicia Manor and Tanya Mason, and I conducted investigation interviews with both of them.
Okay, and
I object as to hearsay. These are statements by people who are not testifying as witnesses. They're out of court statements.
Witnesses too.
I did not call them. I haven't called a single witness. I haven't even had my case yet. And furthermore, you can't call witnesses who are not on your witness list, which they're not.
This is a part of her investigation.
It's
And
still
so
hearsay.
this is a part of her investigation, and she can testify.
She cannot testify to out-of-court statements made by people who are not herself.
We'll let
That is the definition of
chair-
hearsay.
We can let the chair, let me stop sharing. Chairman Barbie, I can't hear you, sir.
So what is, so what is your, so,
Oh, as a matter of fact, I don't need to go into this. I can just ask her the question directly. So I apologize for that. So Miss Poole, if you can continue on with your statements, ma'am.
Okay, I was made aware of text messages and they were saying things such
Objection, that's a
as,
hearsay.
This
You
is a
can't
part
reveal the
her
content of the
investigation.
text messages without the witness testifying.
No,
That's hearsay.
this is a part of her investigation, and this was a part of how she arrived at her decision.
And it's still hearsay. That is the
No.
definition of hearsay.
This is a part of her investigation, and she can testify as to the nature of her investigation and who she interviewed and what was said. And all of this was included in the report as
And
well.
Mr. Barbie, I'd just like a ruling on the objection. It's clearly hearsay to say what someone told me when that person doesn't testify. Ms.
well,
McLean.
Mr. Riley, is the information that Ms. Poole provided within the confines of her investigation, is that included in the report?
The text
Is
message
that information in the report, sir?
No, sir, those are not in the report. She refers to their existence in the report. The text messages she just put on the screen were not in the report. And I will point you
But
to
she's
the,
not using the text. So counsel has withdrawn those text messages, but she can, if she alluded to the text messages in her report, sir, she can allude to the text message in her testimony.
and I agree that she can talk about their existence. The moment she talks about the content of what was said, that is hearsay.
I haven't
She's not-
asked.
I
for
don't
the
think
content.
I don't think that's what she's doing, sir.
She just said there were text messages where they were saying, and I objected when she said where they were saying.
I have not.
That's what Ms. Poole was saying. This is what they were saying, which
Why
is when I
don't we let
objected.
her continue what her statement is before you?
Because
make
I have to object before she says it. That's the rule.
Well, you don't know what
Objections
she's
work.
about to say. Ms.
Please
Poole,
continue, Ms. Poole.
Go ahead, continue.
yes, I can just talk about, instead of the text messages, we discussed them in the investigation interviews. So
Okay.
we can talk about that.
Yes.
They did say that they were hearing
Objection,
Mr.
hearsay.
Brown. Again, this is from an investigation that I conducted where we had the witness and there was information being shared that Mr. Brown was talking about. He went down and someone else was going to go down and that a claim was going to be filed, and that different things were going to happen where they were going to be looking into the sexual harassment issue. And the employees I interviewed had said, Mr. McDaniel said he was
Objection,
okay with
hearsay.
with
Yeah.
behaviors of what were happening of Marcia Mitchell. And then after all of this happened with the suspension, then we were looking at filing this claim. And it was interesting because on 3/15, it was noted the lady from downtown called and Marcus is outside talking to Stan about this whole situation and getting his advice. And in my documents show it was 3:15 when I called him. So everything was matching up. The information I was getting in the text messages was correct. On April 7th, I sent another email to Mr. McDaniel stressing the importance of the confidentiality and that I felt like things were being breached. And I resent the confidentiality agreement because, again, I was told he was sitting in the office with Mr. Brown. Claims were being written. The information, they were filling out the paperwork together. He was being told what to put on it. And, that I just sent him again the email with the confidentiality agreement again, making sure we keep it in place.
And what was the date of that again, Ms.
That
Poole?
was 4/7 when I sent an email to him stressing the importance of please keeping information confidential. Resent the confidentiality agreement again.
Okay, I want to share a document. Let's see here. Okay.
I believe we have a question from the board. Don't want to interrupt, but
There's a number
question?
2.
Is there a question?
Yeah,
There
I
will
have
be-
a question. All this stuff that she's saying in that, these documents that she says she has, why didn't she bring those in here as evidence so we could see it instead of listening to something that is nothing but a hearsay.
And to answer that question,
She's saying that all this stuff, but she's got all this information and she's got all these documents. Where are the documents? Well, show the documents instead of just get up there and start.
sir, I believe you have been provided a packet of documents. And if you search.
And I'd object to there being evidence that I haven't received or reviewed or am not aware has been given to the board.
Yeah, I got them at 10 o'clock when I got here, when have I got to read them?
Okay. Ms. Poole.
Yes.
I want to direct your attention to an email exchange. Do you recall this communication receiving?
And I hate to interrupt, Ms. McLean, but I'd like a ruling on my objection before we move on.
Well, counsel, you have a point. Mr. McLean, if we're going to use documents, I would prefer you submit them into evidence as per rules of the chair. So you go forward. Okay.
I haven't moved for any particular document to be admitted into evidence. I've just been using them for information. At the point that I do am requesting that a document be admitted into evidence, I will make that request. Okay. And then I will submit it electronically.
If the board already has it, then it has been admitted by virtue of them having it.
Well,
they're looking at it right now in the video.
That is just preliminary information that I believe every board member receives relative to an appeal. And the appeal is just standard documents that is included in the appeal packet, I believe, that Mr. McDaniel receives. These are the very documents that were included at the administrative appeal level. So that is a part of this board's procedures. And in fact, I don't receive a copy of that. So you've not been disadvantaged in any way because I don't know the documents that they receive. I just see a packet in front of them.
And my objection is not about being disadvantaged. My objection is not knowing the content of those packets, that those could violate the rules of evidence, which we admitted in the beginning, this hearing is supposed to follow. To the extent that they violate those rules, I am objecting. I can't see them, so I don't even know if they violate the rules or not.
Those are within our purview, and we receive those documents prior to all hearings.
Does that include Ms. Poole's investigation?
But sir, it's the same documents that your client received at the time he filed the appeal.
I just want to clarify my objection, Mr. Barbie. I'm not trying to be rude. I just need to clarify my objection for the record. If those documents contain hearsay, such as Ms. Poole's report, I am objecting to that because her report, if it includes witnesses who do not testify here today, contains hearsay. To the extent it contains that, I'm objecting.
Sir, I'm going to overrule your objection because your objection is based on the documents that your client and that we receive at the time of the hearing is filed.
And that doesn't make it not hearsay, sir. That's all I'm saying. But I'll understand you're standing there or overruling the objection.
Go ahead. Counselor, go ahead. Continue.
Yes. I'm going to share a screen with you, Ms. Poole. Do you see the document that I've shared with you? And I'm just trying to refresh your recollection because a lot has been made of Mr. Brown here.
Yes.
And you received this email on April 5th, correct? From
Correct.
Mr. McDaniel?
Mm-hmm.
Okay. And do you recall the reason for which he sent you this email?
I always tell anyone I'm working with on a case if they have any additional information or if anything happens to share it with me. And so he was referring, that I first told you about in this email, that conversation on February 10th. And he felt like, I guess his issue was he felt like he shouldn't have to be a witness to it because he was off the clock. But again, Human Resources conducted that. And the director, Mr. McDowell, did want to meet with him to hear his side of what happened with that particular conversation in the weight room. Then
And
he
this
went
was
on.
the incident in the weight room for which Miss Mitchell complained of, and which Mr. McDaniel and Mr. Brown was present, correct?
That is correct.
And he did not want to participate in the investigation of that complaint.
Objection, leading. You can't tell the
Again,
witness.
it was a human resource. I wasn't investigating that complaint. That was
Okay.
being dealt with by human resources. But from reading the information that I received, yes, that's what happened. He did not want to be a part of being a witness to what happened.
And although, so you were not investigating the complaint involving Mr. Brown, but Mr. McDaniel brought up Mr. Brown in this email communication, correct?
That is correct. And he was telling me how, he got this suspension and they felt like he was set up when they brought Marcia on because she didn't, Mr. Brown didn't give you a part of the interview panel. And if you even look at the initial complaint and intake paperwork that was given to me by Mr. McDaniel, he wanted me to include a document about an employee, Shamika, someone who was an internal employee, and they were wanting her put in the position that Marcia got. And I told him, it was unusual that he would be giving me that document with his paperwork, but he asked, I just put it in the system. So I just noted, that he had turned it into me that they were thinking this internal employee would be getting the position that Marcia was hired for. And that was like when you first put up the complainant intake form, the affidavit and all of that, that document was included with that.
Okay, so are you stating that in his official complaint on, I believe it was March 16th, he brought up an issue unrelated to the topic of his complaint? He put it in the body of that complaint, and it referred to an employee that was not hired for a position held by Marcia Mitchell?
What happened was, it's not in the complainant intake form, but he did give me the internal document. I'm not sure where he got it from, but showing that this employee, I believe her name was Shamika, was requesting a transfer to the position that Marcia Mitchell was hired into. So Marcia felt like from day one, she was in a pretty hostile environment and they did not want her there. That they were wanting that internal employee.
So I'm going to refer you to page one to the third paragraph
Yes.
up. And I don't know if you see my cursor here. Is this the employee that he's referencing?
That is correct. Yes. Like, why was she not hired? And why wasn't Mr. Brown part of the interview process?
And he's bringing, and this is it, the subject matter of this email is supposed to be, was this in reference to his EEO complaint?
He was just submitting, and again, when he sent it, I asked him to please quit sending it to everybody. Again, it was just confidential with us. It shouldn't have been going to the HR director or to his director at this point. Everything just should be coming to myself. And Swanette Jones at the time was our admin compliance tech. And then, I addressed with him, I believe I probably had conversation with him afterwards, that I had received his information and I would review it. But yes, he submitted it as more documentation with his EEO claim. And then when he talked about Mr. Riles hadn't responded to him, I told him that, that would make sense because it was now being handled by us. So it's out of the department. Then he talked about he was in a hostile environment, that Marcia Mitchell was on meds and state certified. And I reminded him we have to be very careful that people with disabilities are protected under Title VII, and we need to not be making, comments of that nature, even though the employee herself may have said that. We're not going to assume that we're unsafe because someone may be on medication for a mental illness or something of that nature.
Okay, so he's alleging here, he's he states a hostile environment, but he doesn't mention sexual harassment in any way right here. Is that correct?
That's correct.
And I see, is it true? I'm looking just about in every paragraph here, he's mentioning Mr. Brown.
Correct.
I'd object to counsel
Okay.
testifying and leading the witness.
Is that, you see in just about every paragraph, does he mention, Mr. Brown's name is mentioned throughout this email? Is
Yes,
Mr.
he
Brown-
does. Yes.
Okay, all right. So you can go, and I think I cut you off in the middle of.
That's okay. So again, I had received text messages, did my investigation interviews. Information came out that employees were, even saying we feel like
Objection,
that.
hearsay.
Oh,
Okay. Miss Poole, let me ask you this. For the benefit of this board, can you summarize McDaniel's conduct that contributed to your recommendation of termination?
yes, I can. Things were happening. There was an office there, and I guess there was a glass barrier, and Marcia was needing to go in that office.
Objection, lack
to-
of firsthand knowledge, hearsay.
This is in connection with her investigation. Go ahead, Ms.
to do emails on the
I just like a ruling, Mr.
computer.
Barbie, and then we can keep
Yes, sir.
going.
Overruled, go ahead.
She would be going in to get various, she was supposed to clean in the office. There were various other documents, office supplies, things she might need in there. And she was being kept out of the office and saying that she couldn't go in there. She had her own office, or then she could only come in to clock in or out. And she was, would be asking for help. Maybe it was moving a big piece of furniture. She wasn't receiving any help and was being really made to feel like she wasn't performing her job. And she was feeling very unsafe at this point and felt like she was very much in a hostile environment. And like I said, being kept out of areas where she needed to work. And she requested to be moved from the location. She was not feeling safe. She was incurring a lot of stress there. Felt very unwelcome from day one, that they wanted this internal employee and not her. Felt like she wasn't getting the training she should be getting. So we went ahead and on 4/23, we moved her to a different location because she said she felt like she was in a hostile, retaliating environment.
Okay, so let
department-
me stop you there.
Mhm.
Was Miss Mitchell removed from out of that department and placed in another department during the period of time you were investigating Mr. McDaniel's sexual harassment complaint?
Yes, because she was at the Bernie, she was still in Parks and Recreation, but she was at the Bernie Ward Community Center where Mr. Brown and Mr. McDaniel were, and they moved her to the Robert Howard Community Center.
Okay.
And she was experiencing a lot of stress and felt like it was a very hostile, retaliatory environment and requested the move.
Okay, and did she name individuals who she felt were harassing her or creating that hostile environment?
Objection, hearsay, lack of firsthand knowledge.
Did she name individuals?
Overruled.
She did. She named Mr. McDaniel and Mr. Brown.
Okay. And so can you tell the board how many witnesses you interviewed in connection with your investigation of Mr. McDaniel's complaint of sexual harassment?
I interviewed 6 witnesses.
Okay. And did any of those witnesses acknowledge either seeing or hearing any instances of Miss Mitchell sexually harassing Mr. McDaniel?
Objection, hearsay.
None of
Yes,
the
ma'am.
witnesses saw any type of sexual harassment or any of inappropriate actions by Ms. Mitchell. It was mentioned that they heard Stanley and Marcus talk about hips, boobs, and butts and things of that nature, but there was nothing seen by the other witnesses that there was any type of sexual harassment occurring, anything inappropriate. Mr. Brown and Mr. McDaniel were saying she was unpredictable and unstable, and they felt unsafe. The other employees said she's very friendly. They felt very safe. There weren't any issues from the other employees about that.
So were there any, let me ask you this way. Out of the specific McDaniel specific allegations, were any of his allegations sustained or found to be true? Did you have any evidence corroborating the statements that he alleged within the body of his complaint?
I have one employee state that she did ask him, I believe it was going out after their shift or work to go out for seafood, but the employee said they were often offering to get each other food or they were going out, and it wasn't anything of a sexual harassment nature or anything unusual that would happen. And, you know, she heard the conversation and said it was just a coworker asking another if they wanted to go out to dinner or grab something to eat. But that was the only one.
And do you know whether or not that was like a group thing, or was it just her asking him? Can you further, what information did you receive?
I don't know on that. I believe she may have just been asking him, but again, the employee didn't think it was unusual at all, you know, or that it would be considered sexual harassment.
And I believe earlier you testified to having, I think, like over 15 years or some odd years experience in EEO laws or whatever, correct? And you understand what goes into a sexual harassment complaint and what is needed to, okay. And in the course of your investigation, did you find any reason to believe that Marcia Mitchell was sexually harassing him?
Absolutely not, because I look at the same guidelines the EEOC would utilize. I'm going to see where their unwelcome sexual advances. Was Marcus letting Marcia know that they were unwelcome? In the beginning, they were hugging each other. He did state in his statement, you know, he told her he no longer wanted hugs, but overall for the unwelcome sexual advances, it was not substantiated. Requests for sexual favors was not substantiated. Verbal or physical harassment of a sexual nature was not substantiated. Reasonable person standard. Would a reasonable person find the behavior offensive, consider it sexual harassment? It was not substantiated. Was there a frequent pattern of conduct that was persistent and severe to create a hostile or offensive working environment? It was not substantiated. So therefore, I did not find the claims meeting the definition of sexual harassment.
Okay, and at the conclusion of your investigation, did you issue recommendations for the department director? What is the usual course of action you undertake in
Correct. We, in our report of recommendations, we go through what the initial complaint is. We go through statements that we receive from witnesses. We list who our witnesses are, but we don't put exactly who said what, because this can come out in the open records request. In our policy, it states not that the employee is getting the findings and the recommendations, but the department director is. So at this point, you know, we're putting the information out there generically. We've talked to witnesses. This is what we found out. Then we're going to look at past cases. Again, like I said, with the sexual harassment, I'm looking at the definition from the EEOC. We're going to analyze the information we get, look at any evidence, if there's text messages, etc. Then we're going to come up with recommendations from that point.
Okay. And in your summary of recommendations, did you recommend that Mr. McDaniel be terminated?
Yes, I did.
Okay. Did you conclude that Mr. McDaniel displayed harassing and retaliatory behavior toward Ms. Marcia Mitchell?
Yes, I did.
And did you conclude in your summary of recommendation that Mr. McDaniel provided, well, let me strike that question. I think I already asked you that question. Okay. I think that concludes my questions for right now. Okay. The attorney for McDaniel may have some questions for you, Ms. Poole. May have some questions. Yes, sir.
I do. And before, does the board have any? I don't want to make you guys wait for me if you have any.
No, none heard. Go ahead, Mr. Riley.
Ms. Poole, you're familiar with the personnel manual. I think it's also referred to as the PPM.
The 3 p.m. I certainly am.
And you're familiar with Augusta's EEO procedures?
I sure am. It's chapter 2, section 2 of the 3 p.m.
Okay. And is it fair to say that it's part of your job to be familiar with those procedures?
That is correct.
And do your job duties require performing investigations and doing reports on those investigations?
It certainly does.
And when you write reports, do you have special training for writing reports and investigating?
I sure do. As I was saying, just this year, I've had EEOC training on sexual harassment investigations, includes report writing, overall, any type of EEOC discrimination investigations. I've had coursework when I was getting my master's and have just over the years, every year, am taking updated coursework on writing reports and what would constitute sexual harassment or different types of discrimination.
And why do you write those reports?
We write the reports because we are the impartial body that is looking at the information. And then we're going to come back and say, do we feel like this is a substantiated case or not? Here's all of our facts. Here's why we came up with the decision that we did. And here's our recommendations based on it.
And do you write those reports from memory or do you take notes?
A lot of notes, all kinds of investigation, interviews and things of that nature.
And why do you take notes?
Because we want accurate information. I don't just conduct an investigation interview by myself, but I always have my administrative compliance tech in with me to make sure we're getting accurate information and there's not any conflicting information. So I never gather information by myself.
And is it important that your reports contain all the information that might be important to a case?
It is definitely important.
And is it important that you're unbiased during your investigation?
And I definitely am. I've been doing it for all of these 15 plus years and have never been questioned about my being biased or partial or anything like that. Yeah.
And is it important that you're unbiased in how you report those investigative findings?
Absolutely. I'm reporting things factually and based on the evidence and what I find during the investigation.
And you are the one who authored the investigative report in this case, is that right?
That's correct.
And at some point you told Mr. McDaniel, and I'm trying to get your exact words, but something along the lines of, we can't kick off the investigation until you get certain paperwork back.
That is correct.
And is that after he filed his initial complaint?
That's correct.
But I'm going to show you a document. And are these the EEO policies that you were referring to earlier in your testimony?
Yes,
I just highlighted a portion. The EEO office reserves the right to conduct an investigation of any and all complaints, formal or informal, written or oral, and pending or withdrawn. The EEO office also reserves the right to conduct or continue an investigation, even in situations where the complaint is withdrawn. Did I read that correctly?
you did.
And so it wasn't true when you told him you couldn't investigate without that form in March, isn't that right?
No, you have to have an affidavit signed. You have to have signed a confidentiality agreement. You have to agree to the honesty code and all of that. Now you can just come in and talk to me and ask me if I feel like you have a case. We can have an informal consult. And what that's really referring to is when someone comes in and makes me aware of a situation where there is some gross misconduct, sexual harassment, race discrimination, whatever it may be. And then they say, oh, I don't want to do anything about it. I just want to withdraw it. And at that point, that can't happen because I've already been made aware of it. But in every single case that we follow, what we call a formal investigation, it's not going to happen until we have a signed affidavit that we're getting truthful information, confidentiality agreement, permission to investigate, standard across the board. We always follow that consistently.
But that's not what this says. This says oral, does it not?
It's saying it can be formal, informal, written, oral, pending, withdrawn, that we reserve the right, but it's not our standard practice. Standard practice is always going to have the correct forms filled out.
But reserving the right means you can act on an oral complaint even without an affidavit, correct?
I've never seen that happen.
But you can, correct?
I can't answer that because I've never seen that happen anywhere else I've worked or here. And I know in the past, it's never happened here.
I'd like to draw your attention to section 200.016. And these are the EEO policies you said you were familiar with, correct?
Yes, I am.
At the conclusion of the investigation, the EEO office will send its findings to the charging party and the accused. Did I read that correctly?
You did.
And Mr. McDaniel was the charging party in this matter?
That's correct.
And did you send him the findings?
I tried to call him on 2 different occasions. I first like to call people before I send something. We send via phone sometimes, we send via email. I like to first get a feel for how someone's reacting to something and making sure there's not going to be a safety issue or any type of concern or situation that can develop from what I'm saying. And I had left messages for him. And then by the time I spoke to him, he had already been terminated. Again, I make the recommendations. I don't know when that is happening. And at that time, I did tell him, yes, the only thing we would send, I have a draft of it, is that your case was unsubstantiated for sexual harassment. That's all that gets sent out to claimants and respondents, whether it's substantiated or unsubstantiated. And I also said, when he asked, did we recommend termination? I said, yes, that we did. And he asked why. And I said, we handle every case the same, based on information we receive, testimony, any type of documents, evidence, and that's how we handled it. Then the actual report recommendations, the findings, that is saying it goes to the department director. That's not going out to a complainant because we're trying to protect our witnesses. It becomes very obvious who has said what.
My object is non-responsive. I did not ask all of this. We can't hear you, Mr. Barbie. I think you said you can continue reading his lips, but I can't hear you.
I apologize. Yeah, your objection is sustained. Ms. Poole, just answer the question as asked.
Okay, sorry.
And so isn't it true that Mr. McDaniel only received the findings by virtue of an Open Records Act request?
The recommendations, the report findings, that is correct. That is the only way they can be received.
But this says the EE office will send its findings to the charging party. Is that correct?
That's correct. And that means send via email or phone, and that's simply stating, we found your case to be substantiated or unsubstantiated. Then the next line says the department director will get recommendations in the report.
Generally, the findings will be issued within 30 working days after filing a complaint. Were these findings issued within 30 working days of Mr. McDaniel's complaint?
They were not
Yes or no?
often, no.
It says, however, in some cases, the EEO office may extend the investigation time period. If the period of investigation is extended, all parties will be provided with written notification of the new deadline to complete the investigation. Did you send Mr. McDaniel such notification? Yes or no?
We spoke on the phone.
Did you send him written notification as
Not
this
written.
requires? Yes or no?
Not written, no.
And I'll call your attention to hopefully just one more section. Section 200.017. Highlighted the portion I intend for you to focus on. While employees are protected from retaliation for filing EEO complaints, employees who knowingly file completely unsubstantiated or falsified EEO charges are subject to disciplinary action as outlined in the employee handbook. Did I read that correctly, yes or no?
Correct.
And I believe you testified in response to Ms. McLean's questions that absolutely not. Did you find sexual harassment took place? And you found that no verbal harassment took place directed at Mr. McDaniel. Is that correct?
That is correct.
And you said you were only able to substantiate one of his claims, which was that she asked him out to dinner.
Correct.
Is it sexual harassment to call another employee bubble butt?
It could be. I mean, it would depend on the context of it. In this case, Mr. Brown asked her to call Mr. McDaniel bubble butt to see how he would react. So in that case, I would not say it was sexual harassment.
It's okay to refer to another employee by a sexual body part. If
When
your
a supervisor is saying, go ahead and say this to him, I think that would fall on the supervisor.
And if a supervisor told someone to file a complaint, would that also fall on the supervisor?
Supervisors would tell someone to file a complaint if they felt like they had a valid complaint and needed to. Yes.
So if I'm understanding the case that you built against him, you're saying he's responsible for Mr. Brown telling him to file a sexual harassment complaint, but Ms. Mitchell's not responsible because Mr. Brown told her to call him bubble butt.
No, that's not what I'm saying.
Okay, so please explain. You said Ms. Mitchell did not sexually harass Mr. McDaniel because Mr. Brown told her to call him bubble butt.
She was being set up. There was a lot of things going on where they were very close friends. There was a lot of things happening in a hostile environment. It was obvious that things were being said to, they didn't want her there. I mean, from day one, they wanted this internal employee. Mr. Brown didn't get to pick her out. He wasn't on the interview panel. And that was kind of the setup from day one.
You mentioned unwelcome sexual advances. Would it be sexual harassment to call someone bubble butt knowing that calling them a bubble butt was unwelcomed?
Again, it wouldn't be falling as sexual harassment unless it's persistent. That in and of itself, that act by itself one time absolutely would not constitute a case of sexual harassment.
So in Augusta, I can call my manager bubble butt just one time, and that's acceptable?
No, I mean, you can't.
I'm going to object to the argument.
This is
You think very
cross-examination. I'm allowed to be
argumentative.
argumentative.
And you've also asked her the question several times.
Okay, I'll move on from that particular question.
Thank you.
And I'm showing you your report. Can you see this?
Mhm.
Okay, so Ms. Mitchell never denied referring to him.
Now, if it's okay for you, I'm going to do the same. I'm going to object to you sharing. You said that this is all hearsay. So here you
So
are.
hearsay
referring
is
to-
being
No,
offered for
but
the
I'm
truth of
just
the matter.
reminding
I am
counsel, but
impeaching a
go
witness.
ahead. Go ahead.
Impeachment
Well,
is not hearsay.
I've already ruled that it's not, so
Yeah.
go ahead.
And impeachment is not hearsay, even if it were.
I'm okay with it. Go
And
ahead.
number 13, Ms. Mitchell stated that Stanley told her Marcus does not like anyone talking about his bubble butt, and that she should say it to see if Marcus gets offended. Ms. Mitchell said it did not offend Marcus.
That's
So
correct.
she
And,
was told he would be offended if you call him bubble butt, and she still did it.
and was told by her supervisor to do it, and they all laughed about it.
And she still did it, yes or no?
Yes, because her
you.
supervisor told her to.
And Ms. Mitchell stated that she does not recall sending any unwanted body gestures to Marcus or ever setting foot in the janitor's closet since she has been employed there. Did I read your investigative report correctly?
That's correct.
And is that referring to the instance in the janitor's closet where Mr. Mitchell or Mr. McDaniel said that Ms. Mitchell made a sexually aggressive body gesture towards him? Is that what that's referring to?
Yes, yes, it is.
And she says she does not remember ever setting foot in the janitor's closet since being employed there. Was she not the janitor?
I'm not sure where she was getting her supplies from. I don't know what's in the janitor's closet. I just take the information, and she did not recall making that. No one saw her do that. No one ever saw any type of sexual harassment by her, anything being said or done.
Would you find it suspicious that a person who had been a janitor for 3 weeks did not step into the janitor's closet within that 3 weeks?
I would not, because sometimes supervisors set out materials for employees. She was still supposedly being trained. I don't know their process. That's not my department to know that.
Did you ask Ms. Mitchell about her repeatedly asking Mr. McDaniel to work out with her off the clock?
I did. She was wanting a friend to work out with her, and she was just trying to fit in. And, it was made known that he did not want to work out with her. And again, it was a pretty unfriendly environment for her to come into. She was just trying to get to know coworkers. Everyone else there just felt they really, thought very highly of her and felt like she was just friendly to everybody.
So to be friendly to her, he would have to work out with her off the clock, even though she calls him bubble butt against his wishes.
He did not have to work out with her. That was his choice.
But she asked him repeatedly.
I don't know how many times.
Did you ask her? Please, I don't want to interrupt. Please continue.
A couple of times. I mean, not that many times. And the facility was right there, the workout facility where they were.
At work, how many times should you have to say no to someone's
Ask and
unwanted
answer.
advances?
Yeah, let's move on.
What did you ask her what she meant by he's a grown man?
I do not recall that. Her saying that. I would have to look back at all my interview notes to see that.
Did you ask her what she meant by, well, I'm not gay?
I don't recall that.
Did you ask her about her self-admitted lusting after Mr. McDaniel?
I did not recall her ever saying that happened. Again, I look at information that I gather from respondent, claimants, and witnesses and go by the EEOC definition of sexual harassment and consistently do that with every case I handle.
And based on all the training you mentioned, the 15 years of experience,
That's correct.
It is your opinion that repeatedly asking for unwanted hugs, repeatedly asking to spend time off the clock, and calling someone bubble butt is not sexual harassment.
I would not call asking someone to dinner one time repeatedly. I would not call a supervisor setting someone up to say bubble butt as a repeated occurrence. And we're talking, he was giving her hugs initially, and she was confused as to why it changed. So again, if it's so offensive to him, things need to be communicated back, as you know, in sexual harassment cases. And why was it okay initially? Then it wasn't okay. So I think we just have to look at all of the facts and not take things out of context.
I believe that's all I have for this witness at this time.
Thank you. Mr. McLean, you have anything else?
Nothing further from Ms. Poole.
Okay. I have one real quick question, Ms. Poole. I was trying to take some notes.
Yes.
And basically, I'm just trying to understand the timeline real fast.
Mhm.
So Ms. Mitchell filed an internal complaint within the department on the 10th of February.
Correct.
Correct. That was within the that was for the department itself. Had
Correct.
nothing to do with you or anything like that.
That's right.
Mr. McDaniel then contacted you on 2/12 regarding an EEO complaint.
Correct.
Okay. What's significant about, refresh my memory about what's significant. I've got 2/17 written on my notes. What's significant about that date one more time?
2/17 is the day that I emailed all of the paperwork to Mr. McDaniel that would need to be completed. The
So he contacted,
affidavit.
so to be clear, he contacted you on 2/12. You responded to him on 2/17.
Right. We had a phone conversation and told him I would be getting the paperwork out to him.
Okay.
Yes.
All right, okay. On 3/10, Mr. Brown was suspended for 7 days.
Correct.
But that has nothing to do with you. That was based on Ms. Mitchell's original 2/10 complaint.
Correct.
Correct, okay. And then on 3/16, Mr. McDaniel filed a formal EEO complaint with you?
Correct.
Okay.
Completed his paperwork.
Completed the paperwork. And then when did you complete the investigation?
The investigation was not completed until 7/23. And in some cases, we have employees that are out. We're having to work around vacations, multiple interviews, things of that nature. So that is when it was completed.
Okay. And when was he given notification that you completed or you're fine? And so I assume that if you completed on 7/23, that's when you had your findings. Is that correct?
On 7/23, yes, that's when my findings went out. Now, the findings, the report of findings and recommendations, again, just go to the department director, and then copying legal, of
Correct.
course. But then
when was he notified? When was he notified that you had?
on 7/23 and 7/28, phone messages were left for him.
Okay.
On 8/3, he was terminated. Again, we don't know when that's going to happen.
Yeah, I'm just trying to figure out when you attempted to reach him.
Yes.
To notify him that I understand the process. I'm just trying to figure out in my own brain when you try to reach him. Okay. All right. That's all I need. Anybody else got anything real fast? All right. Ms. McLean, do you have any more witnesses?
Nothing further to present.
Okay. All right.
One of the board members has something.
Mr. Masters?
Yes, I'd like to ask Ms. Poole a question.
Go ahead.
Yes.
If employee files sexual complaints and you can't find witnesses, let's take the closet. Nobody's present. Yet you can't prove that he was sexually harassed. So instead of letting him go back to work at different places, y'all fire him. Is that what I'm getting out of this?
Absolutely not.
Couldn't substantiate that he was sexually harassed. Fine. Is that what I'm getting out of this? Instead of both of them going different places.
No, we couldn't substantiate he was sexually harassed, but he was fired for falsifying a claim and for his.
Based on y'all saying you couldn't prove it.
It could not be proved, but we also have evidence.
False statements if y'all can't,
he can't prove it.
And there's also evidence that he was sitting in the office by another person telling him what to put on the form and that they were going to bring Marcia Mitchell down because of Mr. Brown's suspension. And there's also, again, like I said, documentation, text messages, what the employees are saying match up to the day I call him. The lady called from downtown. You know, I've said it's confidential. Don't be talking about it. They're sitting, Stan Brown and him are sitting in the office together filling out the EO paperwork. They're creating a hostile environment for Marcia Mitchell that I had to move from there, not allowing her to come into the office, not giving her training, not helping her with job duties that she can't perform on her own. So that is the firing doesn't have to do with the sexual harassment claim. The firing has to do with falsification of a claim and the behaviors creating a hostile environment for another employee and going ahead and filling out this paperwork with someone else telling you what to put on it.
So still, if you file sexual harassment and he can't prove it, then
No one would be fired. I mean, I've had plenty of cases where that happens.
I just fired him. That's what you do.
We will say it's unsubstantiated. We'll give sexual harassment training to the department if we can't prove it. Often, in most of my cases, 90% of the time, there's text messages. There is a witness. You know, there's other people that have seen the behaviors.
There's not. So he lost his job. Okay.
Not because of that.
That's it.
She answered the question.
What I've got from him, Chair, is most of the stuff that we've brought before us this morning has been hearsay stuff, not a piece of paper here saying what took place. Most of it has been hearsay.
Yeah, Mr. Yeah, that's fine. Do you have a question? Because if not, we need to move on.
Yes, we do.
All right. Mr. Ratley, go ahead and you're free to continue your case, sir.
And I'm ready to go into closing, and I'll be as brief as I can for the board.
Are you ready? Okay. All right.
Ms. Poole, that concludes the questioning. I don't believe there are additional questions for you.
Okay. All right.
All right,
Thank you,
thank
Ms. Poole. We appreciate you. We appreciate you today.
Thank you.
With that,
I think there's a question. A board member has a question.
yes.
Oh, did she have a question of Ms. Poole? She did. She's on mute, sir. And Ms. Poole, if she
Ms.
can
Dunn,
be
you're on
brought back in.
Ms. Dunn, you're on mute.
We still can't hear you. I see your lips moving, but
Now,
There we
now you
go. Ms. Dunn, there you go. Go ahead, Ms. Dunn. You have a question?
Thank you, Mr. Barbie. My question is to Ms. Poole, who was the person who said that he was sitting with Stan, Mr. Brown?
Okay, she's going to be, if you could hold on, Ms. Dunn, she's logging back on. So it just take a couple of minutes, ma'am. So hold 1 second. We didn't see you with your raised hand.
And forgive me, everybody, because when we're doing it this way, it's harder to see everybody all in one fell swoop.
No problem. No problem.
Okay, she's about to come in.
Okay.
Poole, I see you're back with us.
Yes, I am.
Thank you very much. Thank you very much for joining us back. Excuse me, Ms. Dunn had a question for you real fast, one of our board members.
Yes.
Ms. Dunn, go ahead, please.
Ms. Poole, I'm sorry to bring you back on, but I did have a problem with not hearing the person's name who was sitting in the office saying that Mr. Stan was assisting him with the complaint.
Yes, that was text messages I had between Felicia Manor and Tanya Mason.
And that's who was reporting this back to you?
Yes. And that, you know, that's what was happening. And also from them as well, that, you know, it was being said, Mr. Brown said she was going down and that somebody was going to pay for his suspension.
Okay. Thank you so much. And thank you for coming back.
Thank you.
And Ms. Poole, as a follow-up question, Felicia Manor and who was the other person, ma'am?
Tanya Mason.
Okay, for the benefit of this board, they worked in the same department as Marcus McDaniel, Stanley Brown, and Marcia Mitchell?
One is in administration, Tanya is.
Okay.
But Felicia was there with them at that particular center.
Okay, so Felicia was the one who witnessed all of this, overheard those conversations.
Right, but it also made its way back to the administrative office as well, because Mr. Brown would go in and talk to them. So she heard it firsthand as well.
Okay, and you, in the conduct of your investigation, when you put together your report, you list the names of all of those witnesses that you interviewed, correct? Okay, and Mr. McDaniel received a copy of that report, correct?
Through the open records request.
Through the open records, okay. So he could have called these individuals as a witness.
He has no burden
today,
to call
correct?
witnesses.
Correct.
If he wanted to, he could have called those witnesses, correct?
Correct.
Okay, thank you.
Ms. Poole, if Augusta wanted to call those witnesses to meet their burden, they could have called those witnesses, correct?
We never have in the past.
Can you answer my question like you answered hers?
Asked and
Augusta could have
answered.
called those witnesses, correct?
She's answered the
She
question.
didn't answer. She said we haven't in the past. I'm asking a yes or no question.
Yeah, she can answer.
I'm assuming I could. Like I said, I've not seen it done and I haven't done it.
Thank you.
Mr. Routley, you have anything for Miss? You have anything else for Miss?
I'm ready for closing, Mr. Chair.
All right. With that, I'm gonna go ahead and we'll move to a close. Ms. McLean, you can go ahead and start and
I elect to close. I'll just give a close.
Thank you very much.
I believe you said you're electing to go second, as is your right.
Yeah. Mhm.
Okay, all right.
Distinguished board. Yes, sir. The importance of due process is that it allows for an independent and unbiased review of the facts before a decision is made. It allows for notice of the allegations against us. It allows us to confront our accusers. It requires evidence and not just hearsay. But that's not what you heard here today. I asked Augusta to show me the lie, and they failed. Mr. Donald couldn't say what lie he told. Ms. Poole couldn't say what lie he told. Augusta has determined that Mr. McDaniel lied, not because they found evidence that he lied, but because they're simply choosing not to believe him. Ms. Poole chose to label him a liar, even though Ms. Mitchell admitted to calling him bubble butt. Mr. Donald chose to misconstrue and misrepresent his words to uphold his termination. You got to hear what Mr. McDaniel actually said and the context in which he said it. When he said no, sir, he was not denying that Mr. Brown recommended that he file a complaint. He was denying that they colluded. Their refusal to believe him and choice to misrepresent his words does not make him a liar. Augusta chose to bring you three witnesses, and well, actually two witnesses, to meet their burden of proving he lied. And they didn't bring you Ms. Mitchell. They didn't bring you Ms. Manor. They didn't bring you anybody who actually witnessed anything. All they brought you was people who someone told something. No one had personal knowledge that you heard from today. They brought you nothing but hearsay. And the law says they can't meet their burden with only hearsay. In doing so, they're denying Mr. McDaniel the due process the Constitution promises him. Augusta, and not Mr. McDaniels violating the law. And I just want to submit this for the courts or for the board's consideration. I don't want to belabor the point.
I think we've closed all the part where you submit evidence.
I'm not
Let's
submitting
close it.
evidence. I'm submitting the law for argument purposes. This is the case of Neal v. Augusta Richmond County Personnel Board. Neal was a firefighter. Under prior policies, he tested positive for marijuana as part of a random drug screen. At that time, he could bring his appeal to the Personnel Board, which we all know is no longer the case. At his appeal, the city of Augusta chose to put on a case made purely of hearsay, which is what happened today. The Court of Appeals of the state of Georgia said you cannot do that. It said that Mr. Neal, just like Mr. McDaniel, has a right to have a case that is not hearsay, has a right to confront his accusers, and has a right to a fair process. Just like in Neal, they brought you no witness with personal knowledge. They didn't bring you Miss Mitchell. They didn't bring you Miss Maynard. They didn't bring you Mr. Brown. They didn't bring you Mr. McDowell, nor Mr. Riles, nor any of the other 6 witnesses who were mentioned in her report. The law says that administrative disciplinary hearings are neither fitted with all the trappings of criminal procedure, nor all the trappings of criminal procedure. However, each party must be afforded an opportunity to present their case. A fair hearing includes the right to confront and cross-examine witnesses. The significance of Neal's interest in retaining public employment should not be minimized. Our courts have recognized the severity of depriving a person of their means of livelihood. While a fired worker may find employment elsewhere, doing so will take some time, and they will likely be burdened by the questionable circumstances under which he lost his previous job. This case says when you choose to fire someone, you need facts and you need competent testimony, not what someone told someone they heard through the grapevine while talking to someone on their text messages when they should have been working. That's what they brought you. They didn't bring you the witnesses. It is despicable that Mr. McDaniel has nearly 4 years of unblemished service to the city of Augusta, and he's being forced to undergo this process. This panel has an opportunity to right that wrong. This panel can demand more than uncorroborated hearsay to take someone's job. This panel can establish that decisions such as these require more than speculation and innuendo from unpresented witnesses. This panel has more than an opportunity, it has an obligation to act based on the facts. The city of Augusta has been successful in proving only one thing, and that's showing that Mr. Brown was not fit for his job. But it went too far when it attributed Mr. Brown's problems to Mr. McDaniel. Ms. Mitchell didn't complain about Mr. McDaniel. She complained about Mr. Brown. When asked about her complaint, Mr. McDaniel gave true testimony against Mr. Brown, and Augusta found him credible then. To be clear, Mr. McDaniel's corroboration of Ms. Mitchell's allegations against Mr. Brown got Mr. Brown suspended. So why would he lie later to avenge Mr. Brown? If he wanted to protect Mr. Brown and hurt Ms. Mitchell, he could have lied then. And how could he retaliate for Mr. Brown's suspension when it had not even happened when he complained about Ms. Mitchell sexually harassing him? Also, Mr. McDaniel was second in command to Mr. Brown. If Mr. Brown were to be disciplined or fired, it seems that Mr. McDaniel would at least be in consideration for his job. More incentive to lie on Mr. Brown and support Ms. Mitchell, not support Mr. Brown. The most important thing about this case is the investigation by Ms. Poole. It was made up of nothing but hearsay, innuendo, speculation, and lacked any actual evidence that disproved a single one of his allegations. She came here and told you she could only substantiate one, and that was her asking him out to dinner. But she also substantiated that she called him bubble butt. I'm closing. And while Ms. Poole may think it's okay to call someone bubble butt in the workplace, I sure don't. Mr. McDaniel told the truth. The conclusion that Ms. Mitchell did not sexually harass Mr. McDaniel when she referred to him by his body parts instead of his name is absurd. Is that not sexual harassment, or is it okay if a woman says it to a man? Is that the precedent we're here to set today? If Ms. Mitchell called him that name, which she did, she sexually harassed him. And if she sexually harassed him, then his claim was not dishonest and it did not violate any Augusta policy. He deserves his job back. Due process is not just a catchphrase, it exists to protect our rights. Zero tolerance to sexual harassment means zero tolerance when it's committed by a woman and directed at a man. That standard says we will take his complaint seriously, we'll investigate them fully and fairly, and we will demand evidence before acting, and not just base our decision on what we feel. These requirements are not just words from me, they're the demands of the Constitution. Mr. McDaniel has been denied his rights by Augusta. He has a right not to be terminated because of hearsay, but that's what Augusta wants you to do today. By failing to bring his actual accusers before this panel, Augusta has violated Mr. McDaniel's rights under the law. That is why I must ask you to grant the relief he requests. Reinstate him to his position with back pay and benefits, expunge this from his personnel file, and have this panel issue a written finding of no cause to believe he violated any Augusta policy. Plain and simple, he did not lie and he deserves his job back.
Thank you, Ms. Bradley. Ms. McLean?
Thank you. Appellant's counsel has made a big deal of Mr. McDaniel not receiving due process. He has put up case law in front of you that has absolutely nothing to do with this particular case, the facts of this particular case. The fact of the matter is, Mr. McDaniel did receive due process. The due process was in the EEO investigation itself, where Mr. McDaniel had the benefit of being interviewed, had the benefit of being able to submit evidence to support his position, having the benefit of responding to specific allegations made about him. He participated in that process. That was the due process that he was afforded. That was investigated thoroughly by the EEO division of the compliance department. And a report was issued, a comprehensive report, where there were a substantial number of witnesses interviewed, evidence submitted, and you've heard the testimony regarding text messages. Anything in rebuttal, Mr. McDaniel had the opportunity to submit anything in rebuttal. He did not. If he had additional information to present, if there was something that he's alleging the EEO division, Ms. Poole, missed in her investigation, he had every right to present it at this particular time in this forum. He had every right to do that because per the policy of this board, the board considers additional evidence for which he chose not to do. He served me with, he could have called all the witnesses that he said he was going to call. He didn't do that. So what's happening now is all the smoke. They want you to see all the smoke, but they're not dealing with the facts herein, which you were given the facts. And his counsel wanted to make a big deal out of information within the report that he submitted to you on a shared screen. When I attempted to question Ms. Poole about, he made a big deal of it being hearsay, yet his counsel decided to put it up on a shared screen for you. Why? Because he's playing, no, this is argument, and I have every right. This is argument, counsel, and you understand that I can do this in argument because this was presented in the case in chief. So his counsel made a big deal out of hearsay, yet now he's saying that, no, it's not hearsay and I can use it in my case in chief. The fact of the matter is, if you recall his counsel's opening statement, and if you recall the testimony that he gave during his administrative appeal, he says the bottom line is that he filed for Mr. Brown. He filed for Mr. Brown. Now, he wants you to believe that this has nothing to do with Mr. Brown, that it's about a lie. But I tell you, therein lies the lie. Therein lies the lie. Because you heard it for yourself. You saw his email that I put up on a shared screen, the email that he sent to Miss Deborah Poole. And throughout the body of that email, which was supposed to have been about his complaint of sexual harassment, which, minded, if you recall, he never once mentions being sexually harassed in here. He made a big deal out of Mr. Brown being suspended for 7 days, Mr. Brown's complaints not being heard, Mr. Brown's complaint not being responded to swiftly. And he made a big deal of an individual who should have been hired into the position that Marcia Mitchell was working. He wasn't concerned about being sexually harassed. Why? Because there was no sexual harassment. There was no sexual harassment. All of the evidence led to, hey, when you line up the timeline, you're questioning, why did it take so long for him to file a formal complaint? He only filed the formal complaint after Mr. Brown returned from his suspension, is when he decides to file the formal complaint. Minded, his complaint came after Marcia Mitchell had filed a complaint about being harassed by him and Mr. Brown. So understand that there was an investigation going on with Marcia Mitchell prior to him filing a complaint. Okay, so yes, he had full knowledge that he and Mr. Brown were being investigated, that Marcia Mitchell had made a complaint. So keep the timeline at the forefront here, because his attorney wants to just throw up all these smokes, the smoke. He wants to throw up all the smoke. He wants to put this case law that has nothing to do. He wants you to believe that Mr. McDaniel didn't receive due process, when in that particular case that he referenced, it wasn't an EEO investigation. There was not an EEO investigation. So the due process was in the EEO investigation itself, for which he could have called witnesses. He had an opportunity to rebut any and every allegation made about him, but he chose not to. He also had an opportunity to have an attorney present at the administrative appeal, which he chose not to. He could have called witnesses at the administrative appeal, which he chose not to. He could have called witnesses here, which he chose not to. And don't believe the rhetoric that we have the burden, because he wants to persuade you that what we did wrong. And then let me remind you of this administrative appeal hearing. It was nothing but politeness and patience. The administrator let Mr. McDaniel speak. Here, he had every opportunity to speak and present his case in chief. So I'm not going to belabor this, because we've been on this hearing for a very long time, and I appreciate your time and patience because you've all listened intently. But again, as I stated in my opening statement, I'm going to ask that this decision be upheld. Thank you for your time. The decision to terminate, that is. Thank you for your time.
We can't hear you, Chair.
Sorry. I'm sorry. Thank you very much, Counselor, for everything. I appreciate everybody's patience today. And it's been a long hearing. Does anyone have any comments, or I'll take a motion to go into executive session? Is that I can't hear you guys. Does anybody, if somebody would unmute, I can. Am I getting a motion to go into executive session?
Yes. I motion.
If anybody without objection, the committee the personnel board will move to executive session. Can we go into a breakout room?
And Chairman Barbie, I'm going to step away from my desk for a break, and I'll be back at my desk.
Perfect. In 2 minutes. Okay, thank you so much. I appreciate it.
Did you find out about that note?
Ms. Dunn, can you please join the breakout room?
I tried and it took me out.
All right, this time, I'd like to take a motion for us to come out of executive session.
I'll move. Second.
Without any objections, the Augusta Richland County Personnel Board has now resumed the live session and hearing. At this time, I'd like to also call for a motion.
A motion.
Ms. Dunn? Would you like that? You have a motion?
No, I don't have a repeat that, please.
Yes, ma'am. I'm calling for a motion to I need for one of our members to make a motion with regards to what we want to do with the city.
I make a motion, we put him back to get work.
Okay, there's a motion for there's a motion to overturn the city's ruling. Do I hear a second?
Second.
Okay, Mr. Mathis, the motion is on the table. I'm gonna do a roll call vote. Mr. Atkins, since you filed the motion, so you wish to overturn the city, is that correct, sir?
Yes, sir.
Okay. Mr. Masters?
Overturn.
Overturn. Mr. Culver?
Uphold.
Uphold. Dr. Williams?
Uphold.
Ms. Dunn?
Uphold.
Uphold. And the chairman votes to uphold. That motion is defeated. Can I have a motion to uphold the city's, can I have a motion to uphold the city's termination of Mr. McDaniels?
So be it. Or do I have to?
Can I get a second?
Second.
Second.
Okay. All right. Roll call again, please. Mr. Culver, you vote to uphold?
Yes, I do, Mr. Chairman.
Dr. Williams, you vote to uphold?
Yes.
Okay. Ms. Dunn, do you vote to uphold?
I vote to uphold.
Okay. Mr. Atkins, do you vote to uphold or overturn?
Overturn.
Overturn. Mr. Masters, you vote to uphold or overturn?
Overturn.
Overturn. Chair votes to uphold. That motion is carried 4-2. The personnel board, the motion is agreed to. Any other business from the personnel board? I'll entertain a motion to adjourn.
So move.
So moved. Thank you very much, everybody. I appreciate it.
Thank
Council,
you.
thank y'all very much for your day.
Thank you.